Lordship, I may be pardoned to make a mention.
Yes.
Your Lordship, one admiralty suit is
Press admission item number 1, ARBP 10 of 2022.
May I please, my lords?
Yes.
My lords, Annex 1 is the arbitration agreement, my lords. My lords will find the clause, arbitration clause at page clause 48, my lords. My lords, pursuant thereof, my lords, we issued notice under Annex 2, that was the email correspondences. My lords, our main claim is that they stopped paying, the opposite parties stopped paying the rent amount.
All right. Just a notice returnable. Uh, 6th May. Where is the party? Where is the opposite party located? No, what's the address of the opposite?
My lords, the opposite party is there in Haryana, my lords. The
Haryana.
petitioner has the.
Will you be able to serve them by
register-
13th, by 6th May? Will you be able to serve them by 6th May?
My lords, I'll be issuing notice, my lords. My lords, with regard to the returnability of the acknowledgement receipt.
No. I'm just asking you. I'm making the notice returnable 6th May.
Yes, my lords. Yes, my lords.
All right. 6th.
That can be done immediately, my lords.
All right.
Item number 2.
May I please, Your Lordship? Lordship, the arbitration clause is at page 41. Page 41, clause 17 is the arbitration clause. We have invoked the arbitration, that is at page 84.
All right. Notice returnable same. Where is the respondent?
In Orissa only.
All right. 6th.
Sixth.
Supplementary list item number 3.
Right. In this matter, what has happened, there is an arbitration clause. We have invoked the clause. The opposite party was willing to appoint an arbitrator. They have given the consent.
So they filed a caveat, I think.
Yes, they have filed a caveat and they have said that they have got a panel of arbitrators, one among them should be appointed.
That
I said that's not possible.
Correct.
And I gave 5 names.
Okay.
3 judges and
Who's
2
for the
senior
other
lawyers.
sides? They filed a caveat.
Mr. Party,
This public CPWD.
yes, that central government council has filed the caveat and I have served a copy on that.
BK Mohanty is Central Government Council now.
BK Mohanty is for me.
Your
Yes.
Who has filed it?
Pari, my lord, the central government.
Mr. Paddy,
He is there on the line.
you'll have to unmute, I think.
Yes.
Yes, may I audible, my lord?
Yes.
My lord, even though this penal council is there, the amendment is proper, my lord may appoint an arbiter, but I will take instruction in this respect. Let's keep this some other day. The first time it was listed. So
Why have some other day will straight away appoint?
my lord, because either we have to accept 2 stages there. They have to release the DSR. Thereafter again will come to the own panel, my lord. What happened in this case, I don't know. First time it was listed. So either if the panel is there, but after amendment of the statute, the department is going to appoint his own arbitrator, because many cases they are appointing own arbitrator, then dispute is
Also
come.
have a look at Annex 7. I have suggested
Yes.
6 names.
21, that was a notification by the CPW and for a panel of advocates, panel of arbitrators. But after amendment, whether the department is entitled to do it or it is matter of examination. It is better to, my lord, for overcome the all dispute, lordship may appoint any arbitrator, then there is no dispute at all.
That's what. So I'll.
Penal, yes.
What's the value of the claim?
Value will be around 5 crores.
I see.
So that's why I'm praying, my lord, any date, any after 1 week or 2 weeks. Any
All right. Since he appears on caveat, the caveat is discharged. Mr. Pari says that he needs time for instructions. Let's turn 6th May only. 6th May. All right. All right.
Item number 4.
Please, my lords. My lords, item 4, I'm appearing through VC, my lords.
Yes.
This is a fresh application for appointment of arbitrator.
Yes.
The arbitration clause is at page 36.
Okay.
Clause 20, my lords. And thereafter, my lords, on 12th of August 2020, we had sent we have invoked the arbitration clause, which my lords will find at page 108.
All right.
My lords,
All right. Notice returnable 6th May.
grateful, my lords.
All right.
Item number 3. I'm sorry, in that item number 3, fresh arbitrator whom they have appointed opposite part number 3, he has fixed the case to 30th. So let them not proceed further.
Mr. Pari,
yes, my lord.
that arbitrator will not proceed, the one you have appointed already.
Lordship may pan a status quo till that date next week.
Till the next date, no further proceedings shall take place in the arbitration. No further steps shall be taken in the arbitration proceedings. Right.
Item number 5.
May I please, your lordship? I am from virtual mode, my lord. My lord, in this case, I have filed an application for recalling order dated 31/8/2012, when by this order, this honorable court has appointed the arbitration tribunal to adjudicate the disputes, and the matter was referred from 2012. But that is pending since 2012. No progress is there because there is no tribunal is functioning. Because there is no members are there available. Accordingly, from 2012 now 2022, 10 years is pending only. My lord, I pray that a sole arbitrator may be appointed, my lord.
Who's the other side? In fact, on similar case, your lordship has passed this order, where your lordship directed, appointed an arbitrator on 11/6 and transferred the matter from tribunal to the arbitrator.
My lord, I have also filed the order sheet of the tribunal. No arbitration court is not functional.
Right. So you say by an order dated 31st August 2012, this in the present case, the matter had been referred to the arbitration tribunal constituted by the state government for appointment of an arbitrator. However, the arbitration tribunal, which was constituted by virtue of the amendment to section 41 capital A of the Arbitration Act 1940 bracket Orissa amendment, stood repealed with effect from 25th January 1996. There is no arbitration tribunal functional as of now. And therefore, the prayer in the present application is for an arbitrator to be appointed by this court. Mr. Das, learned Aishwarya, standing counsel, has no objection to this course of action. Accordingly, the order dated 31st August 2012 is recalled. And so, whom do we appoint?
My lord, amount is very low amount, my lord. Within 10-15 lakhs, my lord. KB Panda, Kamal Bhai Panda may be appointed, my lord.
All right, Mr. KB Panda, advocate, is appointed as sole arbitrator to adjudicate the disputes between the parties.
My lord, item 6 is same, my lord.
Including their claims and counterclaims. The arbitration will take place under the aegis of the arbitration center.
Item 6.
My lord, item 6 was same, my lord.
All right. A copy of this order be sent to the coordinator arbitration center forthwith. Item 6A.
My lord, one prayer, my lord. A direction may be given to the arbitration tribunal to remit the records to the
Yes.
arbitration.
The records, just pass that order. The record of the arbitration tribunal shall be collected from the arbitration tribunal and entrusted to Mr. Panda forthwith by the parties, by the council of the parties, on the strength of this order. The proceedings before Mr. Panda will commence from the stage which it was before the arbitration tribunal. Right.
Obliged.
Item number 7.
Directed, I have served a copy of the entire brief from the council for the central government because there was a new change in their council. But one intervening circumstance is there in the meantime. They have raised a demand of around 3 crores against me. Against that, I went in SLP, and SLP, that order was stayed. If the lordship appoints an arbitrator also, that person cannot be adjudicated. That's why may I say that let it be deferred for 1 or 2 months so that in the meantime we can get some outcome from the Supreme Court. All right. All right.
Yes,
At the request of Mr. Rao, based on 15 July.
15th July. Yes.
Yes.
Obliged.
Item number 8.
8, my lord, here the honorable arbitrator has returned the reference. A letter from the council is there. Citing its
refusal of arbitrator to conduct the proceedings.
low amount. My lord, may appoint any other.
All right. That letter has been received. Who's for the other side?
But East Coast Railway, my lord, I am appearing.
All right. Letter has been received from the arbitrator. A letter has been sent to the coordinator High Court Arbitration Center stating that the learned arbitrator appointed has declined to continue the proceedings. Paragraph. To the consent of the parties. What is the value of the claim?
Value is low.
Very low.
8 to 10 lakhs.
Any suggestions? Any lawyer you can think of?
Because the senior advocate is returned for low amount. My lord, may appoint any advocate.
That's what. Any advocate is better.
Sir, Prakash Barik. My lord. Prakash Barik.
Prakash Bari, yes.
Prakash Barik.
Yes.
Mr. Prakash Barik, advocate, is appointed as sole arbitrator to adjudicate the disputes between the parties. The arbitration will take place in the aegis of the arbitration center. The records of the arbitration be entrusted to Mr. Barik to continue from the stage where it was. Right. Okay.
Item number 9.
Here the petitioner is offense 306 of Indian Penal Code Lordship and other allied offense Lordship. And he is in custody Lordship since 21/10/2020 Lordship. Last occasion Lordship, while arguing this matter, Lordship has direction given to the State Council to obtain instruction how much witnesses are there and how much time is required Lordship.
Correct.
Now my respectful Lordship, I have also filed
The petitioner has himself filed an affidavit, my lord. Lordship may kindly see affidavit dated, or he has not mentioned the date, but here in paragraph 3, he has stated that on 9/3/2022 and 10/3/2022, no prosecution are produced by the prosecution for examination. Accordingly, the case has been posted to 21st of this month and 22nd for examination of prosecution witnesses.
Oh.
Yes.
And there are total
Also,
26.
I got information Lordship. At 21 Lordship, yesterday there is no PW and 22 is also no PW Lordship.
Lordship, then
And I am in behind
report from the consent PO, my lord. Otherwise,
All right. You say although prosecution witnesses were supposed to be examined on 21st and 22nd April.
yes, ma'am. First 9th of March, 9th of March and 10th of March. On that date, no prosecution witness turned up.
9th or 10th of March. On that day, no PW was produced.
And then subsequently got adjourned to 21st and 22nd of this month.
It
And
got
as per the
adjourned to
statement
21st and 22nd. of April 2022, learned counsel for the petitioner states that even yesterday and today, no PWs were produced. How do you know about today, sir? Mr. Monty?
Mr. Jena.
Mr. Jena? All right. How do you know that today also there's no PW?
PW has been examined, Lordship. Yesterday there has been no PW, Lordship.
All right, that even yesterday there was no PW.
Today till 10 PM I have also got information no PW yet.
All right. And that even today there is unlikely to be any PW produced. A report is called from the PO, presiding officer of the court, to explain when it is expected to complete the examination of the prosecution witnesses.
Yeah, Lordship, my respective submission, Lordship, a glance.
Yes. We'll have it on 29th, sir. Or 29th.
Lordship, my respective submission, Lordship, a glance, Lordship. I am custody since October 2020, Lordship.
Well, he is the husband. He is the husband, and the deceased died within 2.5 years of marriage.
No, is it 304B?
Yes. 304B and 306.
So let's call for the report. No, it's 304B, sir.
Yes, sir, 304B is there, Lord.
6th May, we'll have it on 6th May. Right.
Oblige, Lord.
All right.
Supplementary item number 10.
May I please your lordship? My lord, I am in virtual. My lord, offense under section 302 and 376. My lord, the petitioner is inside custody since 30th/7/2020, my lord. And the FIR lodged against unknown person. My lord,
Lord, on last date, your lordship may kindly see the petitioner was to produce the copy of the deposition.
Correct. So he has not. Have you produced the copies of the depositions?
Yes, my lord, I have already filed.
But he has not served a copy of the deposition to us.
Where is it?
My lord, already filed, my lord.
But you have not given a copy to the consul of the state.
My lord, kindly allow me 1 week time. Kindly taken up next week. I will communicate a set of copy to the state.
All right. Copy of the depositions filed be served upon consul of the state. List on 6th May. 6th May.
Yes, ma'am. Oblige me.
Item number 11.
May I please your lordship? My lord, offense is under section 20B(2)(3) of the NDPS Act, my lord. And the petitioner is in custody since 1st December 2019. And the meantime, charge sheet has been filed, witness has been examined, my lord. Out of 15 witness, 3 witness has been examined. I have annexed the deposition, my lord, as annexure 3, my lord.
What is the quantity, sir?
50 kilo, my lord. 6%, 50 kilo.
That's commercial quantity.
Yes, that is commercial quantity.
In fact, my lord, the petitioner has also enclosed the copy of the deposition of the IO, my lord. The IO has completely corroborated the story, my lord. He has completely stated that this petitioner and 4 others were found in a auto.
So IO has also been examined.
Yes.
So the trial will conclude very soon, sir.
Lordship may direct to conclude the trial.
Direct, my lord. For early conclusion of the trial, my lord.
All right. The court is informed that the IO has also been examined in the case. That view of the matter, the learned trial court is requested to conclude the trial and deliver judgment not later than 3 months from today.
Oblige, my lord.
The bail application is disposed of.
Item number 12.
I may permitted, my lords, to the petitioner. This is an application, my lords, under section 14, subsection 2 of the Arbitration Act, seeking for termination of the mandate of the arbitrator because he has become de jure ineligible under the Arbitration Act, my lords. On section 12(5) read with 7 schedule, the bar comes into play because the arbitrator, there is an interest which he had disclosed, which has come to the knowledge of the parties, and because of that, the parties have sought recusal of the arbitrator. The claimant has sought recusal, my lords. My lords, may draw your attention to the appointment order.
You can move an application even before the arbitrator, right?
The arbitrator, my lords, the procedure is actually under section 14, subsection 2. The arbitrator, my lords, the arbitrator pursuant to our application seeking recusal, the arbitrator, my lords, may draw your attention to the minutes 73 to 75, pages 73 to 75 of the petition.
1 minute.
The arbitrator says that he will deal with in subsequently, my lords. But once he has become de jure ineligible, it goes to the root of his appointment, because of which I am before your lordships.
Now, what happened on 13th April?
13th April, my lords, he said that we informed him that we have moved an application. He has not passed an order. He has just adjourned, circulated in the minutes.
So who's for the NALCO?
My lord, I appeared for the respondent NALCO in this matter. My
Yes.
lord, I'm appearing on VC. My lord, I just want to point out some bare facts in this matter, my lord. My lord, in the first round, they approached the Bombay High Court for the appointment of an arbitrator. The name of the present arbitrator was suggested by the claimant, was suggested by arbitrating the petition in the present matter. On receiving the suggested names, the respondent made a choice of Justice B.K. Patel. My lord, thereafter consent minutes were filed in the Bombay High Court, whereby jurisdiction was conferred on this honorable court by virtue of the agreement between the parties, and Justice Patel was appointed as a learned sole arbitrator. My lord, the statutory declaration in this matter was filed on 9th of September 2021. That is on the eve of the first arbitration sitting on the preliminary hearing. My lord, 8 sittings have taken place. The respondent has deposited substantial chunk towards its share of the arbitral fee. My lord, the pleadings are complete. And my lord, this is highly prejudicial to the respondent after having deposited substantial share after the pleadings are complete.
No, but what do you say on the main plea?
My lord, the present arbitrator, my lord, his younger brother, they are contending that his younger brother is working as the ED.
He's an executive director of the respondent corporation. His younger brother is executive director. He's hit by category number 9 and 10 of the 7th schedule.
My lord,
He is on the face of it ineligible, my lords. So, but this has come to the knowledge of the parties, and the moment and no substantive hearing in the arbitration has not taken place. The moment it has come to the knowledge, we have raised it for the arbitrator, but the arbitrator is refused to recuse, my lords.
My lord, may I respectfully submit, my lord, just one aspect of this matter. My lord, the younger brother of the present arbitrator, he is due to superannuate on 30th of April. And my lord, 30th of April 2022. And my lord, he is holding a position as the ED. My lord, he's not in the controlling stake of he's not controlling the company in any manner. He's not
Executive
managing
director, my lords. My lords, may I draw your attention to the disclosure? The executive, he's the executive director. Is a 61 to 63 is a disclosure. He has disclosed as an executive director, my lords.
My lord, I will just
And regarding the waiver,
comprehensive reply in the matter just to point out the
All right, or say notice. Mr. Gupta accepts notice on behalf of the opposite party and states that he would like to file a reply. Reply be filed within 4 weeks. Joined up before the next date. Till the next date of hearing, no further proceedings in the arbitration shall take place. List on 24th June.
Grateful, my lord.
All right. All right.
My lord, a copy may be shared of a copy of the petition may be shared with us, my lord.
Yes, yes.
Soft copy as well as give it to the local council, Mr. Tarna Mishra.
All right. All right. All right.
Item number 13. Lordship, item 13, I am VC. Lordship, due to slip of list, I could not appear on that date, Lordship. This I am seeking unconditional apology, Lordship. This matter may kindly restored.
What is the matter about?
I am challenging the order of cognizance passed by the London court below, my lord. My senior counsel, Mr. D.P. Dhol, will argue in this case, Lordship. That is my mistake on that I slip of the list, Lordship. I am unconditional apology.
No, where is he? No, be prepared to argue the main case itself before restoring.
Lordship, one pass over.
May it please you. May it please you, Lord Speaker.
Yes.
I'm here. I'm going to argue the case. I'll argue
Yes,
the case.
yes. Yes, Mr. Dara.
My lord, here is the case. So I have challenged the order taking cognizance under Annexure 2. My lord, may kindly see Annexure 2.
Yes.
Where cognizance has been taken for offences under sections 463, 471, 420, 120B,
Yes.
465, and 466 of the Indian Penal Code.
Right.
I read in section 9 of the Orissa Conduct of Examination Act, my lord. Here, what has happened, my lord, I have challenged the cognizance on merit. I have drawing my lord's attention to paragraph 8, that accepting the entire case of prosecution, no case is made out against the petitioner, who was the secretary of secondary board education, my lord. Because the work, well, allegation is that tampering of marks, that is under the control, that is out of the control of controller.
But that will be unearthed only during the trial, whether who was actually.
I'm coming to that. I'm quite conscious, my lord, that position of law in that respect. My lord, I have filed additional affidavit on 25/2/2022, my lord may kindly see.
Yes.
Wherein, my lord, a departmental inquiry has been conducted by my higher officials and I have been exonerated from the charge. Challenging that, my lord, they have preferred a writ. Writ application has been dismissed, and after against that writ, they preferred SLP before the Apex Court. That has also been dismissed. And my lord, this Honorable Apex Court in a recent case, my lord, 2001, Volume 1, SCC Criminal 209, Ashu Surendranath Tiwari versus Deputy Superintendent of Police, was pleased to observe in a case of this nature, my lord. My lord, I have given the citations, my lord, in the earlier.
Where are the citations?
That is, my lord, I have given the hard copy now. Last hearing, my lord, I had given.
But I have an extra copy.
2021, Volume 1, SCC Criminal 209. I have also given a copy to my learned friend on the last occasion also.
Yes, yes.
My lord, may kindly see paragraph 12 at page 215.
Yes.
After referring various judgments, this court then called out the ratio of these decisions in paragraph 38. Paragraph 38 has been, of Radheshyam Kejriwal's case must have been referred by my lord in number of times. My lord, clause VII. In case of exoneration, however, on merits where the allegation is found to be not sustainable at all, and the person held innocent, criminal prosecution on the same set of facts and circumstances cannot be allowed to continue. The underlying principles being the higher standard of proof in criminal cases. My lord, it finally concluded in paragraph 39. In our opinion, therefore, the yardstick would be to judge as to whether the allegation in the adjudication proceedings as well as the proceedings for prosecution is identical, and the exoneration of the person concerned in the adjudication proceedings is on merit. In case it is found on merit, there is no contravention of the provisions of the Act in the adjudication proceeding. The trial of the person concerned shall be an abuse of the process of the court. So I am relying upon this judgment, though it's a judgment of 2021, and this has happened after the registration of the affair, but I am squarely comes under the ratio decided by the Honorable Apex Court in this case, madam.
Yes. Prior to that, what my learned senior is saying absolutely correct. But prior to that, another 3-judge bench was a judgment was there in state of Delhi versus Ajay Kumar Tyagi. Lord, I'm just.
This is the latest case.
If you Lord, yes, my lord, I consider the fact that it was that the judgment which my learned seniors would.
No, but you're not disputing that in disciplinary inquiry she's been exonerated.
No, because in fact that disciplinary inquiry was challenged by the.
No, the challenge made by you after the Supreme Court failed.
Yes, but I have annexed the order also.
Yes, my lord. So if, but my lord, the entire case of the
page 15, my lord, may see the affidavit.
Yes.
The entire case of the petitioner that since he has been exonerated from the disciplinary proceedings, the criminal proceeding on the self-some facts should not continue. My lord.
Correct.
Now, my lord, this aspect, in fact, was first referred to a larger bench, my lord. In I'm just handing it over, my lord. And these judgments were not taken into consideration by the latest judgment. Lordship will see it. Lord. Lordship may. Para 15 Lordship may similar. Now we proceed to consider the question of law referred to us, that is whether the prosecution against an accused, notwithstanding his exoneration on the identical charge in the departmental proceeding, could continue or not. Lordship got it?
Yes, yes.
Yes. Para 60, Mr. Sharma with vehemence point out that this question has been settled and set at rest by this court in PS Rajya, which has held the field since 1996. Hence, at such a distance of time, it is inexpedient to reconsider its ratio and upset the same. Mr. Attri, however, submits that this court, in the aforesaid case, has nowhere held that exoneration in the departmental proceeding would ipso facto terminate the criminal proceeding. We have given our consideration to the submissions advanced, and in order to decipher the true ratio of the case, we have read the judgment relied on very closely. In PS Rajya case, the allegations against the delinquent employee in the departmental.
I think PS Rajya.
Yes, PS Rajya, correct.
The allegations against the delinquent employee in the departmental proceeding and criminal case were one and the same, that is possessing assets disproportionate to the known source of income. The Central Bureau of Investigation, the prosecutor, to access the value of the assets relied on the valuation report given later on. This court in fact found that the value given as basis for the charge sheet is not the value given in the report subsequently given by the valuers. This should be evident from the following passage from para 15 of the judgment. In para 18, thereafter this court in PS Rajya case referred to its earlier decision in state of Haryana.
No, what is today? What is the position today?
Today,
This
disciplinary proceeding.
Rajya's case has also been referred by the latest bench by Honorable Justice Nariman, 3-judge bench also.
But
That is
that-
paragraph
Lord,
9
that
and 10.
pre-judgment-
Paragraph 9 and 10. That has been referred. PS Rajya's case has been referred. That is
No, but not Ajay Kumar Tyagi's
In
case.
fact, the latest judgment has referred to Agarwal, that Kejriwal judgment, Radhesham Kejriwal judgment, which is also a three-judge judgment, my lord. But in that case, my lord, Justice Sadasivan has given a dissenting judgment, my lord. If your lordship will say Radhesham, I don't have the copy of that judgment, my lord. But the three judges bench that is referred to the old judgment of Radhesham Kejriwal. But in that judgment, the Justice Sadasivan has given a dissenting.
No, dissenting means still, what is the legal position therefore? Radhesham Kejriwal is here.
Yes,
correct.
That has been referred to by my lord in paragraph 12. And also
So
taken note
this
of-
again says the same thing as Ashu Surendranath Tiwari.
My lord.
Radhesham Kejriwal says the same thing.
Yes, my lord. ASU, my lord, in ASU is the judgment of 2021, my lord. They have
2020.
20, sorry, my lord. They have followed the judgment. They have followed referred to the
Radhesham
judgment,
Kejriwal.
but they have not followed the larger bench judgment, which was actually referred, which was actually, my lord.
In Ajay Kumar Tyagi.
Yes, my lord.
On this score, my lord, it will be hard again, my lord, which will be taken note of and what is the ratio on that sort.
So how does one, the question really is,
Lord, here, your lordship may kindly hear the petitioner.
no, do you have any order referring the issue to a larger bench in the Supreme Court? No.
This was judgment, which was at para 11. I just read.
No, there are three judge bench judgments. There are 2 3-judge bench judgments of the
Yes.
Supreme Court. Is there any order referring the correctness of either to the larger bench? Is there any reference
no.
to larger? So we don't know that. So we have coordinate strength.
Yes.
2 benches holding opposite views.
Yes.
Mr. Dalai, then what happens? The later one prevails, or
I think, my lord, later on prevails.
although it does not refer to the earlier one.
My lord. That is the view.
But my humble submission is the first one would prevail, my lord. I'll just cite one judgment. I'll
My
cite
lord,
another.
let it be taken up next week, my lord. On this score, I will address part of the court.
All right. You say there are 2 judgments of the Supreme Court of the same bench strength of 3. One taking the view that despite exoneration in departmental proceedings, the criminal proceedings can continue. That is State bracket NCT of Delhi versus Ajay Kumar Tyagi, 2012 9 SCC 685. And the other taking the opposite view, namely that once in the departmental proceedings, a person is exonerated, then on the same set of facts, criminal prosecution cannot continue. Bracket Ashu Surendranath Tiwari versus Deputy Superintendent of Police, EOW CBI, 2029 SCC 636. Full stop. However, the decision in Ashu Surendranath Tiwari makes no reference to the earlier decision in Ajay Kumar Tyagi. Full stop. It, however, refers to the decision in Radhesham Kejriwal versus State of West Bengal, where by a 2:1 majority, a 3-judge bench of the Supreme Court 2011, 3 SCC 581, whereby majority of 2:1, a 3-judge bench of the Supreme Court held the view similar to the one taken in Ashu Surendranath Tiwari. Full stop. It may be noted here that now look at this. Well, Tyagi makes no reference to Radhesham Kejriwal. We noted here that the decision in Ajit Kumar Tyagi makes no reference to the decision Radhesham Kejriwal. Supra. Paragraph. Mr. Dalai states that he would like to examine the legal position in view of the above conflicting judgments. Before that, the CM is allowed. This CRMC 3407 of 2010 is restored to file. And in this CRLMC, this order will be passed. Then see interim order to continue. Yeah, interim order to continue. List on. We'll have it on 13th May.
Yes.
13th May.
Item number 14. That's item number 14, my lord.
So here, in fact, there is no dispute because out of 17 crore something, we had already paid by the last date 11 crore something, and remaining was 6 crore something. By now, it is only 4 crore something. Let's say keep it on July sometime. In the meanwhile, everything can be paid. I hope so. Because
Yes.
there is no dispute. is there.
Right. Out of 17 crores, 19 lakhs or 13 crores, 29 lakhs has been paid pursuant to the petition being filed before Lordship. What remains to be paid, excluding interest, is, my lord, 4 crores 70 lakhs 36,987 plus interest.
Yes.
Yes, ma'am.
Why there is no dispute at all? That
They have admitted the amounts, my lord.
So we'll have it on 22nd July, sir.
My lord,
Yes,
just clarify, my lord, sir, on the last occasion, Lordship had said, pursuant to my learned senior submission, that amount balance was 695, but interest portion was not reflected. As if, my lord, they have admitted an amount. All would like, I know it's 11.6 petition. I cannot make that submission. Lordship would kindly reflect that balance amount that is to be paid is 4
matter is not going to be adjudicated because we have admitted the dues and are paying the amount.
987 plus interest. What about your Lordship, please?
We'll simply adjourn it, Mr. Patnaik.
As your Lordship deems fit.
Right. At the request of Mr. Monty, the senior counsel appearing for the opposite party. List on 22nd July. Yes. 2020.
Item 15.
Your Lordship. This is an application for appointment of arbitrator, Your Lordship. The notices has been already issued on the last time, and there is a tracking report that the notices have
Anyone
been
appearing
delivered.
to the other side?
I am appearing on behalf of the respondents.
Huh.
We filed the Vakalatnama yesterday.
Okay.
Please allow us 8 weeks time to file the objections.
All right. Counsel for the opposite party states that he will file his reply within 8 weeks. Rejoined up for the next date. 22nd July.
Right. All right, Your Lordship. Obliged.
Item number 16.
Please, Your Lordship.
Well, the controversy here, my lords, is whether clause 45 of the contract is an arbitration clause or not. In fact, there is a ruling of this honorable court which says that a similar clause has been held to be an arbitration clause where the disputes are to be adjudicated by the competent authority who is above the engineer in chief. Your lordships have also given a similar judgment while sitting in the Delhi High Court, my lords. That is the MCD, my lord, SMS Limited South Delhi Municipal Corporation case, where your lordships have interpreted a similar clause to be an arbitration clause. But a judgment is being relied upon by the opposite side, my lords, which is a judgment of the apex court, which says that such a clause will not be a regular arbitration clause. Here, my lords, that is why we'll have to examine this position if there are subsequent judgments. And here the distinguishing factor is, my lords, during the pendency of the contract, I cannot go for a civil suit. That is reflected in the contract itself. Then I cannot be left remediless.
Lord, Your Lordship, before replying to the statement of my learned senior, my Lord, Your Lordship may kindly see the clause 45 and 46 of the
Page 92.
Page 92.
Yes.
If the contractor considers any work demanded of him to be outside the requirements of the contract or considers any drawing record or ruling of the engineer in charge on any matter in connection with or arising out of the contract or carrying out of work to be unacceptable, he shall promptly ask the engineer in charge writing for written instruction or decision. Thereupon, the engineer in charge shall give his written instruction or decision within a period of 30 days of such request. Upon receipt of the written instruction decision, the contractor shall promptly proceed without delays to comply with such instruction or decision. If the engineer in charge fails to give his instructions or decision writing within a period of 30 days after being requested, or if the contractor is dissatisfied with the instruction or be heard and to offer evidence in support of his appeal. The authority shall give his decision within a period of 30 days after the contractor has given the said evidence in support of his appeal, which shall be binding upon the contractor. Now, Lordship may come to next clause, resolution of disputes. A. All claims are to be settled by a
Be opposed to public policy. If it is an arbitration, he could have moved to section 9.
But 47 is there, my lord. My lord, in fact, he can always claim damages, my lord.
No, why should he wait? Suppose he
Lord,
wants urgent
if-
interim
Lord,
orders,
if the
he
parties
doesn't have
to
to
the-
wait till the period of contract is over.
Lord, if the parties to the contract have specifically agreed not to include the arbitration
That's the
clause.
whole point. This is whether such a clause is valid at all, 46B.
But my lord, in fact, the very recent 2019 judgment, in fact, in my counter, I have relied upon 2 judgments of the Supreme Court, but similar clauses, not exactly identical, my lord, but was there, but there the Supreme Court has said that, my lord, since there is a departmental mechanism already available in the agreement, my lord, for the parties to adhere to that departmental mechanism instead of filing an application for under 11(6) of the Arbitration Act. Lords may kindly see. Two 2019-11 SC 776, my lord. Lords may kindly see paragraph 10, my lord. The decision of this case turns on the answer to the question whether clause 16.3 of the agreement dated 14/5/11 between the appellant SDMC on one hand and the respondent
So
SMS.
it's very similar to our 45.
It is very similar, my lords, except, my lords, the distinguishing factor is there is no prohibition to go to civil suit. And a judgment of this honorable court, which has been followed subsequently also, and where the arbitrator has been appointed and award has been given, rule of court has been made, that is Keshav Chandra Mahanti. But, my lord, certainly if the apex court.
Supreme Court has held.
Yes, my lords. So that is why, my lords, I am praying for 2 weeks' time to find out if there are any judgments to the contrary.
Another judgment, Supreme Court 2019.
Just one.
Counsel for
Give
the
me the
opposite party
reference.
relies on the decisions of the Supreme Court in South Delhi Municipal Corporation versus SMS AAMW Tollways Private Limited, 2019-11 SEC 776 and
my lord, Municipal Corporation of Greater Mumbai and another versus Pratibha Industries Limited, 2019 3 SEC 203.
Get us that. To urge that clause 45 of the agreement between the parties cannot be construed to be an arbitration agreement. Mr. Kanungo, Mr. Milan Kanungo, and senior counsel appearing for petitioner seeks time to examine the legal position and prays for seeks time to examine legal position in light of the above decisions. List on 24th June. All right.
Deeply obliged. Deeply obliged.
Item 17.
Item 17, I'm in virtual mode.
Yes.
Arbitration clause is at page 16. Your lordship will find clause number 25.
No, sir, I am asking for the opposite party number 1. If your lordship will permit me, on the last occasion, he has suggested for compromise. I have taken instruction. Let this matter go to the conciliation center for compromise between the parties.
All right.
Settled out of court, then it is well and good.
All right. Mr. Dash?
Yes, I have no objection if my friend
All right. All right. Both parties agreed to attempt resolving the disputes through mediation.
I am for the number 213. I am also agree to.
parties on all sides, he said. Council of the parties, all the parties agree to resolve the dispute through mediation. Accordingly, the parties or their opposite representatives shall be present in the High Court Mediation Center at 3:30 p.m. on 4th May 2022. The report of mediation be placed before the court on the next date.
Just may I pray next Friday, a date after 4th May, any date after 4th May.
No, we'll have it in
Let it
8th July.
Oblige.
8th July, sir.
May I pray for little bit earlier, my lord, because I have been harassed. Admitted claims are not being paid.
All right, 24th June, sir. 24th June.
Oblige.
Item number 8. If it is possible on May, in the month of
May, there are vacations,
May,
that's the only problem, sir.
in the month of
Oblige.
Item number 18.
Item number 18, my lord, pursuant to the direction of this honorable court, dated 4/3/2022, the matter was referred to the mediation center, and parties have settled their terms.
Oh, very good.
Mediation report has come, my lord. The order is there.
All right.
With little variation, payment is to be made. I have started making payments as per the.
All right. You see, pursuant to the orders passed by this court.
Now, that can be taken on record and form part of the order.
Right. The
And in
parties
case
have
of default,
settled
my
their
lord, I shall be in a
disputes
position to
at the
execute
mediation
that.
center. The report of mediation dated 30th March 2022, signed by the parties, containing the agreement between them, is taken on record and made part of this present order. The parties are bound by the settlement and will abide by it. The petition is
But
dismissed.
in case of default, the arbitration is there.
Yes,
the
yes.
losses stayed
See, in
in-
case of default, it will be open to the parties to seek appropriate remedies in accordance with law.
The arbitration should continue or will dispose of that?
No, no, the arbitration proceedings will conclude on the strength of this order.
Yeah, the arbitration.
Because this will come to
a
an end.
directed stay of the arbitration.
Stay of the final award is been stayed by your lordship.
Okay, in view of this order, the final award passed by the arbitral tribunal will not be given effect.
He has not passed any award.
Not passed an award,
Just-
because lordship stayed in the first hearing.
All right, he said the arbitration proceedings will be treated as closed. Bas, that's enough. All right.
Then I should be in a position to execute the order in case of default.
That's it. That's an appropriate remittance. Yeah.
My lord. Oblige.
Yes, yes.
Matter listed on the special list. Orders item number 1.
The office report has been perused. The order be corrected as indicated. Yes.
Special list item number 2.
May I please.
I'm giving a copy of the list of argument, list of date and argument.
Yes.
May I please, Your Lordship. Your Lordship may kindly go through the list of dates. Your Lordship got it, man?
Yes.
Malad, check number so and so were issued by the petitioner in favor of the complainant, which were dishonored due to exceed of limit. Then 39/2005, the complainant sent lawyer's notice to Piyush Gupta describing him as the managing director of the company, protection manufacturer. 1/3/2006, two complaint cases were filed in court of SDGM Sadar Cuttack against Piyush Gupta, the describing himself as managing director under 138 NI Act. The learner SDGM took cognizance of section 138 Act only against.
So there are two petitioners here. You're using petitioner in the singular.
My lord, no. Initially, what happened? The checks were bounced. They gave notice to Piyush Gupta, describing himself as a managing director. Later on, they got information that actually Piyush Gupta is not the managing director. The managing director is Pritesh Gupta, and his wife Vandana Gupta is the director. So therefore, after exhausting those remedies, the loss notice was sent. Thereafter, complaint cases were filed against Piyush Gupta. Again, they filed an application to implead Piyush Gupta as a party in those complaint cases. In those complaint cases, it was rejected. They did not assail any that order before any higher authority. Subsequently, what happened, for the self-same cause of action, they filed a complaint case alleging 138 as well as 420 IPC. So that the learned court below had taken cognizance of the offense. Therefore, I am covered.
No,
Yeah.
my only point which I made was, if you open the petition, sir,
yes,
you have the petition, this
yes,
CRLMC.
Yes.
If you look at the cause title,
my lord,
there are two petitioners.
Actually, protection manufacturer company is a petition.
Sorry?
Protection manufacturer, yes, two petition. Yeah.
One is Vandana Gupta, the other is Pritesh Gupta.
Yes.
In your note which you have handed over,
my lord,
you're using petitioner in the singular.
Sorry.
No. So we need to know who issued the checks. Did petition number 1 issue or petition number 2 or both of them?
Petition number 2. Petition number 2.
Do we take it? What you're saying is correct, because in this note which you have handed over, you simply say petitioner.
Oh, fine, sir.
Is it petition number 2? Are you sure?
My lord, I'm just getting it from the complaint case. Accused number 2. The accused before presenting the due date.
Where is bookmarks?
My lord, your lordship may kindly see page 38 of the complaint case. There, 8G, they have said the accused number 2 made request to the complainant.
Accused number 2?
Accused number 2 means Pritesh Gupta.
He issued the checks.
Yes.
Now, why have they included Vandana Gupta as a director, is it?
As a director.
I see. So what is your case now, sir?
My lord, my humble submission before the honorable court is, so far as 138 NI Act is concerned, it was already issued against Piyush Gupta and subsequently issued, that is barred by the law of limitation as provided under section 142 of the NI Act. That they have also admitted in their counter. In para 12 of the counter, they have admitted that. My lord, should I show the provision, my lord?
Yes.
Yes. Your lordship may kindly see 142 of NI Act. Notwithstanding anything contained in Code of Criminal Procedure Code, no court shall take cognizance of any offence punishable under section 138 except upon a complaint in writing made by the payee, as the case may be, the holder in due course of check. Such complaint is made within 1 month of the date on which the cause of action arises under clause C of the proviso section 138. Proviso C says 30 days notice, thereafter 15 days. If they fail to make payment within 45 days, the cause of action arises. So here the cause of action arises in the year 2005. In 2007, they filed an application for complaint under section 138 as well as 420 IPC. So that is the reason I say, and they have admitted in their counter in para 12. Lordship may kindly see. they have filed a counter affidavit. Prasanna Kumar Naik has filed a counter affidavit. In para 12, he has submitted the submission made under ground number 4. Yes. Partially correct, in as much as admitted to the extent that cognizance offense under section 138 of the NI Act is barred as per provision prescribed under section 142 NI Act. So far as 138 it goes. Right. So far as section 420 IPC is concerned, yes, my lord, I rely upon 4 judgments of the apex court that I have given. I'll only show it to your lordship. My lord, first case is at page 6 of the my note. Yes.
Umar Shankar Gopalika.
Yes, Umar Shankar Gopalika. Para 5 at page 7, my lord. Para 5.
Yes.
Challenging the first information report, the appellant moved the High Court on so-and-so by filing petition under 482 of the CRPC for quashing the first information report and consequent police investigation in which, at the time of issuing notice, police investigation was stayed, but ultimately, by the impending order, the High Court dismissed the application, whereafter a petition for grant of special leave to appeal was filed before this court. By virtue of the interim order passed by the High Court as well as this court, the police investigation remains stayed for a period of 6 years. Now the question to be examined as to whether, on the facts disclosed in the petition of complaint, any criminal offense whatsoever is made out, much less the offense under section 420, 120B of the IPC. The only allegation in the complaint petition against the accused person is that they assured the complainant that when they received the insurance claim amounting rupees 4,20,000, they would pay a sum of rupees 2,60,000 to the complainant out of that, but the same was never paid. Apart from that, there is no other allegation in the petition of complaint. It was pointed out on behalf of the complainant that the accused fraudulently.
So here, what is the allegation as far as the
here the allegation is both two checks were there. I'll show to your lordship that 2 checks were issued. They did not pay. I ran for 1 year for making necessary payment, but they did not pay despite my repeated requests. They did not pay.
So no other allegation.
Madam?
No other allegation.
No other allegation.
All right.
Only allegation is they have mentioned that fraudulently they have delayed payment or they have not paid. So therefore, the section 420 is applicable. My lord, next, my lord, your lordship may see the G. Sagar Suri, para 13, at page 14, my lord. My lord, apart from 5 lines above from in para 13, apart from, it starts from apart from.
Yes.
Apart from making the omnibus statement that the first informed appellant was dishonest intention and in misrepresentation got loan of rupees 50 lakh from the complainant company for Ganga Automobiles, there is nothing said to what were those misrepresentation added, how the complainant company was due. The only part attributed to the second appellant is the first appellant along with so-and-so, with the directors of Ganga Automobiles. There is nothing stated in the counter affidavit about the role, if any, played by the second appellant. A complaint under 138 of the negotiable instrument has already been filed by the complainant. There is no allegation of any corrupt practice by any of the accused, as if the Duke Finance Company in parting with the amount of 50 lakhs.
Yes. What do you say?
Lord.
My case is
may submit that from the complaint case. I will show 2 things thereafter. Your lordship may hear. My lord, with permission.
All right.
Page 38, para 8G.
Yes.
the checks before presented in due date on 2nd May 2005. The accused number 2 made request to the complainant to defer with presentation of the check as the accused persons were short of funds, as because the checks issued for the first 3 consignments were bounced on presentation, the amount of which were subsequently paid by the accused company in 2nd week of May as well as in the 1st week of June took refund of the dishonored check bearing number so and so. Thus, the complainant received an amount of rupees 69,962 out of the total supply amount of so and so. The complainant accepted the request as the same situation very often arises during normal course of their long-standing business relationship. Thereafter, my lord. Para 40, 8N. The complainant, when fully satisfied that the accused persons are not in a mood to pay his legally enforceable dues and intending to cheat him, finally issued a notice on so-and-so to clarify their mindset by registered post, giving a fortnight time, but the accused persons preferred to remain silent. So these are the allegations to constitute the offense of 420.
All right. Yes.
My lord, in my opinion, as per the apex court decision, first of all, the intention must be at the very inception when they entered into that arrangement or contract. And arrangement is in several times they have issued checks. Thereafter, they have taken return of that because of the good relationship of the two. Again, they have presented the check, and some cash was also presented. And so, therefore, there is no element of.
Let me ask him now. Yes. What do you say, please?
Hello. The thing is here, my learned friend tells that as there is no inducement, so no question of cheating.
So 138, you have no answer.
No.
Okay. Only on 420 now.
I am only on 420.
All right.
Milord, thing is, a bunch of checks has been given for an amount of 2,79,542 after I have supplied the goods to him. And out of this said amount, only 69,000 rupees, 69,962 was paid to me, and it was given impression to me that the rest of the checks will be replaced and subsequently it will be paid. And continuously he took up, issued the checks, takes it back, and gives a fresh check on the plea that some financial problem is there, and they will sort it out, and subsequently things will be clear. But continuously he gave checks and taken back it, and again I give fresh checks. But in the finality, it is found that he is not in a mood to pay up the amount or clear the checks. So when the accused failed to get any response from the accusing questions in regard to his payment, he was finally forced to file this complaint, as because initially he was given impression that Piyush Gupta is the managing director, as because Piyush Gupta was handling all the affairs in the company in questions. Pritish Gupta never handles anything. And as because P. Gupta, the signatures available on check is P. Gupta, and Piyush Gupta was there all the times in the office, the OP number 2 believes that he is the person who is actually the person in charge of the company in questions. But subsequently, after checking out with the memorandum of articles and other things, he found that Piyush Gupta is only a shareholder, and this Pritish Gupta is the managing director of the company, and Vandana Gupta, the wife of the Pritish Gupta, is also taking care of the management of the company in questions. For that purpose, in the latter stage, this complaint has been filed, and everything has been clarified there that he is the managing director and other things. So,
how is 420 made out, sir?
Milord, orders were placed.
How is section 420 made out?
Milord, things is, order was placed. I get my goods to the petitioners, and they paid me some money in the initial stage, and thereafter started giving me checks. So I was induced by that process that he is going to pay me my dues. On good faith, I provided that the supplies what they intended, and they given me checks, taking it back again, reissued the checks.
You're repeating yourself, sir. This is what you said some time ago. How is this amounting to the offense under section 420 IPC? That is the question that you have to answer.
Yes, ma'am. Basic things is,
do you have any judgment to cite? He has cited two judgments which say that these kind of allegations are not enough to attract 420.
Lord, at this juncture, I have not brought that anything. Let it come after.
No question of adjournment. Yes. There is no question of adjournment, sir. You carry on with your arguments. Yes.
I have not got on the last occasion when the matter was adjourned. The point of issue was that whether a second complaint can be filed on the self-same issue or not.
Yes.
For that purpose, I was come ready with that various.
It's all right. Every time you can't keep adjourning for you to be ready. All right. So you have to answer the question.
Milord, for that purpose, the notes of submission has not been given to me.
I'm giving it.
That's okay. This is only a note of submission. It's not some pleading. Yes.
So right now I'm getting it, Milord. So let me give in.
No, we're not adjourning it. Sorry.
For that purpose, I cannot bring any citation to make sufficient of submission. Short adjournment may be given any day.
No. You see, the present petition by Vandana Gupta, bracket petition number 1, and her husband Pritish Gupta, bracket petition number 2, seeks the quashing of an order dated 18 June 2008, passed by the
SDJ and further conduct.
Learned Subdivisional Judiciary Magistrate Cuttack, taking cognizance of the offence under sections 138 of the Negotiable Instruments Act 1938, 1888, bracket NI Act, and section 420 of the Indian Penal Code, bracket IPC, in complaint case 1CC 272 of 2007, filed by opposite party number 2. In brackets other reason. The facts in brief are that. Which is the second case is by the company itself.
First case is against the direction given to police under to proceed under 156(3). That is 731. And the after taking cognizance, this is case.
All right. CRLMC 731 of 2008 is by the company, that is Protection Manufacturer Private Limited. Bracket petition number 1, Pritish Gupta, bracket petition number 2, and Vandana Gupta, bracket petition number 3. Assailing an order dated 24th March 2007, passed by the SDJM, bracket Sadar Cuttack, directing the complaint petition to be sent to the IIC Madhupatna for investigation under section 156, bracket 3 of the Code of Criminal Procedure 1973, bracket CRPC. Paragraph. The background facts are that TMPL is a company engaged in the manufacture of air coolers and electrical goods. Full stop. It placed an order for different types of cardboard boxes required for packaging its air coolers with Messrs. Utkal Packaging Industry. The opposite party number 2, complainant, delivered the goods with effect from 19th February 2005 to 9th April 2005 the total value of which was 279,542. Paragraph. Although payment of rupees 69,962 was made by the company, that is PMPL, the checks issued for the remaining amount were dishonored by the bank on account of single quotes exceeding of limits, unquote. Paragraph. The lawyer's notice against the company is within time?
Within time. Piyush Gupta, not company.
Initially, the complainant filed 2 complaint cases. One CC number 1146 of 2005 for a dishonor of a check number 741220 and 1145 of 2006 for dishonor of check number 741221 under section 138 of the NI Act as well as section 420 IPC. So cognizance in the both complaint cases was taken against one Piyush Gupta, who was described as the managing director of the company. Full stop. Cognizance is taken only for the offence under section 138 NI Act against the said Piyush Gupta. Paragraph. Subsequently, ICC case number 272 of 2007 was filed by the complainant against the present petitioners. This time mentioning that Pritish Gupta is the managing director of the company. And since the checks were dishonored, there was a fraudulent intention of the petitioners to cheat the complainant. Admittedly, the said complaint was filed on 21st March 2007 in the court of the SDJM Sadar Cuttack, who issued notice to the IIC Madhupatna police station for investigation under section 156 bracket 3 CRPC. The complainant stated to have filed an application in the existing complaint cases, that is 1CC 1145 and 1146 of 2005. Seeking summons to issue to Pritish Gupta as well. Full stop. However, the said application was rejected by the SDJM Sadar Cuttack on 12th July 2007. That order was allowed to become final. Paragraph. Coming to know of the order taking cognizance. The order passed by the SDJM Sadar directing the IIC Madhupatna to investigate the matter. The first CRLMC 731 of 2008 was filed. Subsequently, when cognizance was in fact taken, the second CRLMC 1290 of 2011 has been filed by Vandana Gupta, the director of the company, and Pritish Gupta. What is Pritish Gupta? Managing director. Managing director of the company. Paragraph. It may be mentioned here that by an interim order dated 27th April 2011, it was directed that The NBWs issued against the two petitioners shall remain stayed. Full stop. In CRLMC 731 of 2008, it was ordered on 2nd March 2008 that no coercive action would be taken against the petitioners in connection with the Madhupatna PS case number 34 of 2008, paragraph. Consequently, the petitioner has urged 2 points. Full stop. One, that the complaint as far as the offence under section 138 of the NI Act was concerned is barred by limitation in terms of section 142 of the NI Act. So he points out that in the counter affidavit filed in CRLMC 1290 of 2011, there's an admission by the opposite parties to the same effect. Paragraph. As regards the order taking cognizance as against the petitioner for the offence under section 420 IPC is concerned, reliance is placed on the decisions of the Supreme Court in Uma Shankar Gopalika versus State of Bihar, 2005, 10 ACC 336, and you say Veer Prakash Sharma versus Anil Kumar Agarwal. Paragraph 50. Yes, 1 minute. (2007) 9 scale 502. G. Sagar Suri was the State of UP. (2002) SEC 636. And judgment of this court in Sunil Kumar versus Escorts Yamaha Motors Limited, 2018 OCR bracket SC. No, and the judgment of Supreme Court, Sunil Kumar versus Escorts Yamaha Motors Limited, 2018 OCR SC, 67, to urge that the complaint as it presently reads does not make out any case against the petitioners for the offence under section 420 IPC. Paragraph. Counsel for the opposite parties, on the other hand, urge that while the offence under section 138 NI Act may not be maintainable, while the complaint for the offence may not be maintainable on the ground of limitation, it was certainly maintainable for the offence under section 420 IPC. He referred to the fact that the petitioners had sought to replace the bounced checks with fresh checks, which again were dishonored on presentation. And therefore, this reflected the intention of the parties not to make payment. According to him, the ingredients in section 420 IPC were fully made out vis-a-vis the two petitioners. Paragraph. The above submissions have been considered. As far as the impugned order of the learned SDJM taking cognizance of the offence under section 138 NI Act is concerned, it is plain that vis-a-vis the two petitioners in criminal MC 1290 of 2011, the notice under section 138 of the NI Act was not issued within the time stipulated under section 142 of the NI Act. Stop. In fact, none of those time limits were adhered to. Stop. Consequently, the SDJM was in error in taking cognizance of the said offence against the two petitioners by the order dated 18 June 2008. Even vis-a-vis the company and the two directors, that is the DAPL, Vandana Gupta and Pritish Gupta, the attempt at proceeding against them under section 138 of the NI Act was done belatedly. Therefore, the SDGM was in error in directing the IIC Madhupatna to investigate the said complaint under section 163 CRPC as far as the offence under section 138 NI Act is concerned. Paragraph. Turning now to the offence under section 1420 IPC. A perusal of the copy of the complaint filed by the petitioner shows that it only refers to the factum of checks having been issued which were dishonored. Full stop. It also refers to the fact that the accused persons offered to substitute the check with other checks, which again were dishonored on presentation. The accused are stated to have deceived the complainant fraudulently with the dishonest intention, inducing the complainant to deliver the stock as per the indent placed, and thereby committing the act of cheating. Full stop. Paragraph. While this averment appears to borrow from the language of the statute, going by the explanation of the ingredients of the offence as by the Supreme Court in Umar Shankar Gopalika, Supra, G. Sagar Suri, Supra, and B. Prakash Sharma, Supra. There has to be some specific act of inducement by the petitioners herein revealing an intention to cheat the complainant from the single quote's very inception, unquote. In the present case, part payment was in fact made of rupees 69,272. Full stop. It does appear that attempts were made at making payments despite the first two checks having been dishonored. Full stop. The averments in the complaint seem to be made only to satisfy the language of the provision rather than refer to actual acts of the accused, which could lead to even to a prima facie opinion of the offence of cheating having been fulfilled. Stop. Consequently, on a reading the complaint, it appears that the necessary ingredients of the offence under section 420 IPC cannot be said to have been made up against the petitioners here. For the aforementioned reasons, the impugned orders of the learned SDGM assailed in both the petitions are hereby set aside, and the complaint case against the petitioners is hereby quashed. The criminal MCs are allowed in the above terms, no orders to us.
Specialist item number 3.
Greatly obliged.
May I please your lordship?
Yes.
My lord, here I have challenged the order allowing the petition that was filed by the prosecution for re-examination of the alleged victim. Now here the prosecution case is that there was a affair between the accused petitioner and the victim, which ultimately culminated in marriage. That is the statement of the victim. I will point out to your lordship. And he says, we had a relationship on mutual consent. That is the statement in cross-examination. May I just, with your lordship's kind permission?
What is the age of the victim, sir?
But the age is, my lord, here not a factor. Age is 33 years at the time of examination. At the time of incident also, it is more than 18.
All right.
But basic issue is the question that is being sought for to be put during re-examination by the prosecution, whether in the fact situation of the case is permissible or not. In this connection, I beg to draw my lord's kind attention to Annexure 2, page 15. The first paragraph itself, your lordship will kindly find last 4 lines. May I just place it?
Yes.
Our marriage had taken place in the Shiva temple of Pulipal, where by exchange of garlands we accepted each other as husband and wife. This was a secret marriage where no one else was present except myself and the accused. So therefore, she speaks of a marriage by exchange of garland and nobody was present. She doesn't say it's a promise to marry or anything that sort. Then your lordship will kindly turn to page 17 of her deposition during cross-examination, paragraph 6.
Yes.
Paragraph 6 towards middle portion, your lordship, the cohabitation of myself with the accused was done with mutual consent. My lord, got it, my lord?
Yes.
My lord. Then your lordship may kindly see the petition. The other things are there, my lord. I am not again placing it. Paragraph 8 and 9 at page 18, she again admits marriage and everything. Then now this petition under Annex 3 at page 21 is filed by the prosecution. Your lordship may kindly see the ground on which it is being filed. May I just place only 2 small paragraphs, ma'am?
Yes.
PW1, victim and the informant has been cross-examined and she has deposed to have consent for cohabitation with the accused. Now it is learned that the consent of the victim was upheld by the accused on promise of marriage. This fact is to be established by re-examining the witness. I pause here for a moment. Your lordship has seen the deposition of the victim. He doesn't speak of, say about any promise to marry. He says we have married. That is the positive statement by the victim that we have married. Now, my lord, your lordship will see whether this is also permissible in re-examination, because the prosecution says there has to be a re-examination. Then the paragraph 2 is that furthermore a document that is writing in the village punch is with the said PW, who is today present in the court for evidence. The said document is to be marked as exhibit for just and proper adjudication of the case. Your lordship will see also again the deposition, though she has spoken about a meeting, my lord. I have to consider that she has spoken about a meeting, neither in the FIR, nor in the 161 statement, nor during the deposition in court, she has ever stated about any document being reduced to writing. In any event, the re-examination purpose is only clarification of what is being put in the cross-examination. That is what the 138 my lord speaks of. So therefore, my humble submission would be, first of all, the paragraph 1, which the prosecution sought to clarify, will certainly amount to a new case or filling up a lacuna, because the positive case of the victim is there is a marriage, there is no question about the promise to marry. Your lordship will see 158 direction for re-examination. It says the re-examination shall be directed to the explanation of matters referred to in cross-examination, and if new matter is, by permission of the court, introduced in re-examination, the adverse party may further cross-examine upon that matter. So here what has happened, your lordship will see, here the statement is very clear. So they want to just altogether introduce a new thing so far as paragraph 1 is concerned, your lordship will see. So therefore, my humble submission is that this impugned order, and in fact, I filed a detailed objection to it under Annexure 4, and thereafter your lordship will kindly see the impugned order. The relevant decision.
Page 25. 25.
Much obliged, ma'am. So, para 2.
Yes.
This court.
Yeah.
The court heard respective parties at length relating to the respective contentions piloted by them, relating to re-examination of the witnesses and marking of a document as exhibited. To do complete justice, this court considered that re-examination is a statutory right of the person who calls the witness in support of its case. Re-examination of matter which were raised in cross-examination is permissible in law under section 138 of the Evidence Act. However, if any new matter is introduced in course of re-examination, the same can only be done by the permission of the court, and if the permission is granted, the other side has a right for cross-examination on new evidence adduced during the stage of re-examination. This is a case relating to the year 1997. PW1 is alleged victim of the case as per the FIR. The evidence of PW1 is no doubt the most important evidence for prosecution. The evidentiary value of any document or oral can be judged at the stage of argument or judgment. This court doesn't find any prejudice is caused to the accused if the petition filed by the prosecution is allowed. The learned counsel for the accused has right to cross-examine the witness on any new matter raised by the witnesses at the stage of re-examination. In these circumstances, this court allows the prayer of the learned APP to put questions relating to the matters raised in the petition filed by the learned counsel for the prosecution on 15/9/2011 and also file additional evidence if any. Now again, your lordship may kindly see, there was no prayer for additional evidence. This also, my lord, I have challenged specifically saying the petition was not for any additional evidence. Petition was for re-examination. Even if the court thought, yes, this piece of document, namely the minutes of meeting, which is stated in paragraph 2 of the petition, is to be brought on record by the victim, and I will be given a scope of cross-examination, that may be permissible. But so far as paragraph 1 is concerned, which your lordship has been pleased to peruse, with regard to this promise to marry, this is an introduction of a new thing. This is not a clarification to the cross-examination that has been made. So therefore, this part of the
All right.
this part of
Let me ask. Yes, Lord, I'll first read the section 311 of CRPC. What is the power given to the court while to
Recall a witness.
to re-examine? So what has been re-examined?
Correct.
Any court may at any stage of any inquiry, trial or other proceedings under this code summon any person as a witness, comma, or examine any person in attendance, comma, though not summoned as a witness, or recall and re-examine any person already examined, and the court shall summon and examine or recall and re-examine any such person if his evidence appears to it to be essential to the just decision of the case.
So that's the last part. The last part is what is important.
Yes, my lord. Now the prosecutor, unfortunately, I don't have the office brief, my lord. But what my learned senior just now told me, lord, I don't have the brief, my lord. AG office brief. You can take it.
Evidence Act. Indian Evidence Act.
But 26 is the impugn order. No?
Yes. No, the only question is she is very clear in her examination that they in fact got married and that cohabitation was with consent. So you can't try and introduce a new case saying that it was on a promise to marry and therefore we have to examine her.
This court heard the respective, I'll just taking only the operative part, I'll answer your lordship. This court heard the respective parties at length relating to the respective contentions by them relating to re-examination of witness and marking of a document as exhibited. To do complete justice, this court considered thus the examination is a statutory right of the person who calls the witness in support of its case. The examination of matters which were raised in cross-examination is permissible under section 138 of Evidence Act. However, if a new matter is introduced or in course, re-examination of the same can only be done by the permission of the court, and if the permission is granted, the other side has a right for cross-examination.
Actually, there is no reason given except saying that there is no prejudice going to be caused to the accused. How can you say that? A completely new case is sought to be projected, right?
138.
So he has no objection to the second part of the request about marking one document. That he says they can do, but only recalling her and re-examining. That's what he's objecting.
Yes, my lord. Because 138 direction for re-examination, the re-examination shall be directed to the explanation of matters referred to in cross-examination.
Correct.
And if new matter is by permission of the court introduced in re-examination, the adverse party may further cross-examine upon that matter. So the right has already given to the other side.
No, not just for the asking. It's not that mechanically anything that you ask, the court is supposed to grant. That's not what the provision is for. It must be with the view to doing complete justice. That's what section 311 says.
Yes, but my lord, if the learned court below in his judicial
No,
wisdom-
that's why the reasons. That's why the court passes an order. We look at the order to find out what the reasons are. There are no reasons except to do complete justice.
Yes.
When he has filed objections, first of all, those objections have to be dealt with.
Yes.
There's no dealing with those objections.
He has not offered any explanation. He has not cited any reason for issuing an.
That's right. That's the whole problem. You see, the challenge in the present petition is to an order passed by the learned subdivisional judicial magistrate Baripada in GR case number 216 of 1997, allowing the plea of the prosecution to re-examine the prosecution witness number 1, bracket PW number 1, acceding to the application filed in that behalf under section 311 of the CRPC, read with section 138 of the Evidence Act. At the outset, it must be noted that the application filed by the prosecution made two requests to the trial court. One was for re-examining PW1, who was the victim and the informant in the above GR case. And the second was for marking a document, that is the writings in the village punch paragraph. Mr. Samir Mishra, learned counsel for the petitioner at the outset, states that as far as the second request is concerned, the petitioner has no serious objection insofar as it has been allowed by the impugned order. However, he points out that by allowing the first prayer for re-examining PW1, the attempt by the prosecution was to introduce a new case, and therefore that was impermissible in law. Paragraph. In her deposition before the trial court, PW1 stated that the marriage with the accused had in fact taken place in a temple by exchange of garlands, and that, open quotation, we accepted each other as husband and wife, unquote. In another place in the cross-examination, she makes the statement that, open quotation, the cohabitation of myself with the accused was done with mutual consent, unquote. While the final view on these statements will be taken by the trial court, and nothing more need be said at this stage, a perusal of the application filed by the prosecution reveals that in para 1, it is said, open quotation, now it is learned that the consent of the victim was availed by the accused on promise of marriage, full stop. This fact is to be established by re-examining the witness, unquote. Clearly, therefore, the attempt by the prosecution is to introduce an element of, open quotation, promise of marriage, unquote, when in fact the victim has clearly stated that both of them in fact had got married by exchange of ballots. The critical phrase in section 311 of the CRPC, which permits the trial court to summon any person as a witness or to recall and re-examine a person already examined, is that it should appear to the court, open quotation, to be essential to the just decision of the case, unquote. Under section 138 of the Evidence Act, there can be a re-examination for explaining the matters referred to in the cross-examination. But if a new matter is to be introduced, permission of the court is necessary. Full stop. These powers have to be exercised for valid reasons, which have to be spelled out in the order to be passed by the court. Full stop. It must be noted here that the accused had filed detailed objections to the application filed by the prosecution for recalling PW1 and examining her once again. Full stop. A perusal of the impugned order dated 26 September 2011 of the trial court reveals that these objections have not been dealt with at all. So, in fact, there is no reference even to the reasons why the prosecution sought recall of the witness. Full stop. The trial court simply states, open quotation, to do complete justice, comma, this court considers that re-examination is a statutory right of the person who calls the witness in support of its case, unquote. And then concludes that, open quotation, this court does not find any prejudice is caused to the accused if the petition filed by the prosecution is allowed, unquote. In the considered view of this court, the trial court lost sight of the fact that there were two distinct matters prayed for in the petition submitted by the prosecution, which required a different approach, each of which required a different approach, different consideration. Full stop. As far as the first request for recall and re-examination of PW1 was concerned, the trial court was expected to deal with the precise prayer of the prosecution and the objection thereto by the accused, and then determine whether, in fact, a wholly new case was sought to be introduced by the prosecution. To stop. The trial court appears to have overlooked this requirement. To stop. Paragraph, it does appear to the court that the prosecution is seeking to, was by making the above prayer for recalling PW1, seeking to introduce a new element to the case, which ought not have been permitted given the statements made by PW1 in her deposition before the court. Consequently, the impugned order of the trial court dated 26 September 2011, to the extent that it permits recall of PW1 for re-examination, is hereby set aside. The remaining part of the order, however, is allowed to stand. The interim order is now vacated, and GR case number 216 of 1997 will now proceed in accordance with law. The petition is disposed of in the above terms.
Obliged. SL list item number 4.
My lord, here I have filed the application challenging the order of convenience. First, may protest petition, my lord.
Yes.
My lord, the petitioner was working as a doctor, my lord, and the complainant has assaulted him and have abused him in filthy language, for which a FIR was lodged. That is under Annex 6, my lord.
Yes.
And after 1 month of the occurrence, a complaint case was filed and it was sent for under section 156(3) and the FIR was registered. And after investigation, the police has submitted a final report that the allegations are false and a counter blast to the FIR filed by the doctor. Now your lordship will kindly see, so far as section 3 SC/ST Act is concerned, the cognizance which was taken.
No, who is the doctor here now? The petitioner?
Petitioner, my lord.
Ah.
He has been assaulted by the complainant who was at that relevant time was a sarpanch, my lord. For which, my lord, a FIR was lodged.
Who's for the other side? Who's for the complainant?
In spite of the notice, my lord,
No, has they been served?
Yes, yes, my lord.
No, you are aggrieved by the closure report, is it?
The closure report, my lord, is in my favor, my lord.
Ah.
Closure report is in my favor. After investigation, final report was submitted, holding that it is a counter blast to the FIR lodged by me. Second thing, my lord, the allegations are wrong.
So now you are seeking the staying of the quashing of the case filed by him against you.
My lord, the protest petition, cognizance was taken against it after my lord, final report was submitted.
I see. He filed the
protest petition.
The Sarpanch filed a protest petition.
My lord.
Ah.
Against which, my lord, the cognizance was taken.
I see.
And so far as 3 SC/ST Act is concerned, my lord, 3, my lord, it is public view, my lord. If the incident took place inside the room of the doctor, my lord, your lordship will kindly see the complaint petition at page 12, my lord.
I'm just seeing whether AD card after valid service. All right.
My lord.
All right. Yes.
The complainant is to hard in this case.
That's what he's been served. That's why I'm seeing opposite party number 2.
Yes.
There's a written objection at flag B, it says. So he says he belongs to BPL category, unable to go to Cuttack to engage a lawyer to defend himself.
He is a sarpanch, my lord, elected sarpanch of the.
Still.
In the complaint.
You have the copy of that objection he has filed.
No.
So you better take a copy. We say on 7 July 2014, opposite party number 2 complainant has sent a written objection to this court, which is at flag B. Copy thereof we supplied to Ms. Mahapatra, learned counsel appearing for the petitioner. The court in the said objection, opposite party 2 contends that he belongs to the ST and under the BPL category and therefore is unable to engage a lawyer to defend him. So in that view of the matter, the Secretary High Court Legal Services Committee is directed to assign a counsel of not less than 10 years standing to appear for opposite party number 2 in these proceedings. A copy of the paperwork will be made available by the registry to the Secretary OHC LSC, who in turn will provide it to the assigned counsel forthwith. Stop. A direction is issued to the assigned counsel to get in touch with the complainant to seek instructions. Interim order to continue list on 15th July. Right.
Specialist item number 5.
Yes. The order of cognizance under Annex 1 is under challenge. once the order of cognizance in the same case was quashed by this honorable court.
Yes.
Initially, the order of cognizance was taken and that was quashed by this honorable court, saying that its lack sanction, it was prior sanction was necessary under the UAP Act. Since it was not taken, it was out of jurisdiction and the proceeding is vitiated. Relying on a Supreme Court judgment, this was quashed. The day it was quashed, the very next day, a supplementary charge sheet was submitted and cognizance was taken. Again, after 1 month, another supplementary charge sheet was submitted. And I have challenged in this impugned order, both the charge sheet were dealt and
No, till date, no sanction has been granted.
This is the order. This time, my lord, they want to rectify the mistakes and filed another charge sheet again under the UAP Act. But this the court, lower court also didn't agree with that, didn't take cognizance of the same. But under IPC, on the supplementary charge sheet, it has taken cognizance on the same proceeding.
No, but this time sanction was obtained.
No,
Oh no, because it's IPC, there's no need for a sanction.
Yes,
Correct.
yes.
Correct.
This time sanction was not necessary.
All right.
And this time the cognizance are taken on a purely on a different facts. The allegation so far as the FIR is concerned on a different thing, and this cognizance was taken upon the charge sheet, the investigation report on a purely on a different facts. That is how it amounts to, with humble submission, I would say that this amount to fresh investigation and not maintainable under section 173(8). And this is because this lady now presently she's a lawyer working, practicing in Bhubaneswar court since 2016, and even she contested in the election. And she is leading a regular life, but because of this case, my lord, this has been stayed by this honorable court. And now, my lord, this cognizance was taken purely because she is supposed to be the wife of the leader who was heading the Maoist program in Odisha. That's why she was being targeted, and this cognizance has been taken one after other. My lord. This is the order. This honorable court was the order.
What are your instructions?
My lord. My lord, in fact, the impugned order itself reveals the sequence of events that ultimately resulted in taking cognizance by the learned court below, my lord. But initially, offences under section 16, 17, 18, 20, 21, 38, 40 of Unlawful Activities Prevention Act.
That was quashed by this court.
Yeah, that was quashed by. Subsequently, the investigating authority made fresh investigation and obtained the sanction, and then filed a supplementary charge sheet in this under this on 16, 17, 18, 20 of Unlawful Assembly Activities Prevention Act, read with section other offences of section of IPC. Now, my lord, this learned court below did not also take cognizance of these offences under section Unlawful Activities, my lord, because they said that the learned court below observed that the second, although the sanction has been obtained in the meanwhile, but it was not obtained as per the direction of the Honorable High Court, and only taken cognizance under the offences as alleged, as has been charge sheeted under IPC offences, my lord. So therefore, and there are materials also, my lord. If your lordship will see page.
So which provisions of the IPC 121A, 124A?
467, 471, 474, 120B. So waging war that was initially which was there is not in the current impugned order, my lord, because it was found that the wife of Waji, my learned senior, said that he is the wife, she is the wife of one of the Maoist of our state, my lord. Now in the last was previous page, my lord. However, the second supplementary charge sheet relates to commission of offence under section 467, 71, 474, 120B against all the accused persons. Peruse the CDs and other connected documents submitted by DSP, CIDCB and with the original case record. On the perusal of the documents, it is found that at the time of submission of preliminary charge sheet, the cell deed executed by Susmita Das seized in this case was sent to Director Fingerprint Bureau SCRP Rasulgad for examination. After submission of charge sheet, the specimen handwritings and signatures of accused Milipanda alias Subhashi Das was collected and was sent to Handwriting Bureau Rasulgad Bhubaneswar for their examination, and reports thereof were also received. Further, it is found from the case diary and other documents that the accused Milipanda had managed to obtain voter ID card, driving license, SBI passbook, birth certificate for her daughter, PAN card, etc. in the fake name of Susmita Das and intentionally done forgery to conceal her identity. Similarly, now this case is confined to the only Lord Subhash Das alias Milipanda. So the learned court will take to cognizance against the offences under section IPC against the present petitioner and one Millard Kishore Jena. Initially, the FIR was registered under the offences of unlawful activity.
So now we are only concerned with this 467, 471,
Yes.
spread with 120B.
Yes, there are materials available. In fact, during investigation, it came to the.
What do you say? This once there is a handwriting expert report and all that, you can't say that there is no prima facie case for cognizance.
The allegation relates to all total a different story, Miller. A vehicle was carrying some leaflets.
Right.
It was caught hold of.
Right.
And it was found that on direction of this petitioner, that is the allegation, and it was going to be distributed among some people in Ganjam district.
Right.
That is the only allegation. Now here, after the cognizance order was quashed, Miller, they came out with a supplementary charge sheet again saying, probably trying to rectify the same, but it was not accepted. The cognizance are not taken by the court. And again, in the third supplementary charge sheet, they brought out this section 467 so and so, unconnected with the allegations made in the FIR. So my humble submission is that it amounts to fresh investigation, and the facts that reveal, they say that because of this handwriting expert, all these things related to some other issue, not this issue what is there in the FIR. Once the proceeding is quashed and
in the course of investigating a particular offence, right, if you come across the commission of other offences, are you precluded? That's the only question.
But here, once the cognizance is quashed, and because of lack of sanction, it vitiates the entire proceeding. And subsequent to that filing of any charge sheet, anything where cognizance taken, that amounts to a fresh investigation.
No, was the FIR itself quashed?
FIR, FIR not quashed. FIR is not quashed.
No. So what did this court do? That's a question. Only a cognizance order
yes,
was set aside.
For want of sanction.
But they
not the FIR.
Yes, for want of sanction only the cognizance order was.
Not the FIR, but
no. So in the course of investigating that FIR, if they find, if they detect commission of other offences, what precludes them from proceeding against the person for those other offences?
What they say, Lord, that the handwriting expired, all these things, probably we don't have any knowledge about the report of the.
No, that you will get. Once the charge sheet is filed, all the documents with it will be supplied, all that.
So,
I'd rather that you withdraw this, because this is only on a limited extent of those 467, 471, for which there is a prima facie case.
Well, that was what precluded them not to file these sections while filing the first charge sheet, because the day it was passed, the very next day this charge sheet was filed, and within 1 month after this second charge sheet was
That's
filed.
all right.
That's right. So that was not with the intention. The materials are available.
I'm not inclined. So you decide if you want to withdraw and urge all these points at the appropriate stage. Do that.
Yes, sir.
Counsel, the petitioner seeks leave to withdraw this petition with liberty to urge the contentions raised in the present petition at the appropriate stage. It's disposed of, is withdrawn with liberty is prayed for. The interim order stands vacated.
Specialty item 6. Each one. Under section matter 323 and 294 and 379 and 34 of IPC and section 3 of SC/ST Act matter. Here is a case. Your lordship go to FIR. Sorry, my lord, this is ODI FIR. But there is no whisper of Jati, the caste there is no whisper about caste. But however, the FR laws in the SC/ST section, and also your lordship go to the answer 2 of the page 10 and 11, Mr. My lord, your page 11, para 8, it clearly mentioned that it is arising of a civil dispute, and the chief Ponda, knowing how to use the law for his own purpose, has engaged one person of Maudhunt as his driver, who belongs to a scheduled tribe. Whenever the villager came to the protest of the activity done by ashram on said land, the man is deployed to face protesting villagers so that they could have tussle, including abuse the person, and in return they get a SC/ST case against them. At least 3 such cases under SC/ST Act have been registered as Sama and Pujam PS on the report of said person since in the Chiranjan Hemlam. We are bound to register a case evidence against the persons tussles abusing the person belong to the tribal community. That is report of a superintendent of police of Jagatsinghpur, my lord. And your report is, my lord, you'll also go to the detailed report. I am going to also page para 3 of the page 10, my lord. That also comes to Mr. Ponda claim that he has got around 60 acres of land from government quota. Thus it becomes 170 acres. But many villages come to allegation about ashrams and land between ashrams and the private persons. That the private person employ a ST community member, and so the FIR laws, madam. This is my law, madam, my case, madam.
Not inclined. If you want to withdraw it and then urge all these plates at the appropriate stage. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to urge all the pleas raised in the present petition at the appropriate stage. Disposed of is withdrawn with liberty as prayed for. The interim order stands.
Specialist item number 7.
May I please, your lordship? My lord, the petitioner seeks to challenge the order framing charge dated 11/11/2010 passed by the learned SDJ Bhadrak in GR case number 766 of 2008, my lord.
Yes.
Which is at Annex 2, my lord.
Yes.
On the ground that the dispute between the parties is purely civil in nature, my lord.
Yes.
And the remedy lies in only in civil code, my lord.
Yes.
And but with oblique motive in the the informant has cloaked a civil wrong as a criminal offense, my lord.
Let's see that. What is the basis for you to say that?
My lord, may I draw your kind attention to page 3 at para 3, my lord.
Yes.
The gist of allegation is that the informant was doing cable TV business in the name and style of Annapurna Network. It is alleged that on dated 16/8/2007, the informant signed a contract with one Mahesh Cable Network owned by the petitioner number 1 and took cable connection from the network run by the petitioner number 1 on payment of rupees 15,000 towards infrastructure expenses, my lord. As per the agreement, the informant had to pay rupees 40 to the petitioner number 1 for each TV connection. It is further alleged that in violation of the contract, the petitioner number 1 provided cable connection to another TV network named and styled as Konark Network. It is stated.
All right. How is this a criminal case, please?
Well, it's pure civil. It has given a criminal color.
Cable connection being given to some other channel will become 420. It's too much. Has the opposite party number 2 been served?
Hello?
The complainant, has he been served? Sorry? Oh, he appeared. Okay. Today none is here. You see, the challenge in the present petition is to an order dated 11/11/2010 passed by the learned SDJM Bhadrak in Bhadrak RPS case number 122 of 2008, framing charges against the present petitioner for the offences under sections 406, 420, 506, 294 and 34 IPC. Paragraph. The case of the petitioners is that a civil dispute has been converted into a criminal case and that it is an abusive process of law, and therefore no charge ought to have been framed by the learned trial court. Paragraph. The gist of the complaint filed before the SDJM Bhadrak, read as under, take from page 3, that whole paragraph. None appears for the opposite party to number 2 complainant despite service. Paragraph, having heard learned counsel of the parties, the court is of the view that the above allegations prima facie reveal a dispute regarding cable connection being provided on payment, and this can hardly be treated to be the case of cheating or criminal breach of trust. Stop. Consequently, the impugned order dated 11/11/2010 is hereby set aside, and GR case number 766 of 2008, and the petitioners will stand discharged in GR case number 766 of 2008.
Bless man.
Specialist item number 8.
Item number 8, my lord, I'm appearing through virtual mode, my lord. I'm
Yes.
On behalf of my learned senior advocate Subhashish Patnaik in this case, my lord. Here, my lord, I have challenged the order passed by the learned SDGM Bhubaneswar in 1cc number 2982 by 2010, wherein he has rejected my petition under section 205, my lord. At the time of filing of the 205 application, my lord, I was 80 years old, and already 10 years have elapsed, and he rejected my prayer without any just grounds, my lord.
All right. You say the present petition questions an order passed by the learned SDJM Bhubaneswar in 1cc number 298 of 2010, rejecting the petition filed by the present petitioner, who at the relevant time was already over 80 years old, for exemption from appearance under section 205 CRPC. Stop. Having heard learned counsel of the parties, the court is of the view that the SDJM Bhubaneswar should have, keeping in view the age of the petitioner.
Petition number 1.
Petition number 1. Yeah. Before the court, that is Vaishnav Charana Pradhan, allowed to pray under section 205 CRPC. The impugned order is accordingly set aside only to the extent of declining the prayer of the present petitioner, that is Sri Vaishnav Charana Pradhan, from appearance in the trial court. The petition is accordingly disposed.
Specialist item number 9.
9, my lord, it has become infructuous, my lord.
Counsel of the petitioner states the petition has been rendered infructuous, disposed of as such.
Item number 10. Specialist item number 10.
None appears dismissed for non-prosecution.
Specialist item number 11.
In this case, when cognizance was taken under section 498A, after 10 years of marriage, my lord, the FIR has lost. My lord, I pray, my lord, your lordship may kindly be taken up next week, my lord, so that I will take instruction what is the status, my lord, because divorce proceeding was pending, other things were pending. That's why, my lord.
All right. At the request of learned counsel, the petitioner list on 5th May. 5th May. Interim order to continue.
Specialist item number 12.
May I please your lordship, my lord? In this case, I have file has been misplaced, and I have gone through the fact from my learned brother, my petition I have read. The discharge petition, rejection of discharge order application has been challenged in this case, and in the meantime, 10 years has already been passed, and the trial has already been started by the fast track court Malkangiri.
So you withdraw this, sir.
So I pray if your lordship wants to dispose of the case with the observation that I will raise all these points before the trial court, and the trial court
Counsel
will
to
deal with
petitioner
this
seeks leave
matter
to withdraw this petition.
without being influenced by this order of rejection, the impugned order.
All right. The counsel, the petitioner seeks leave to withdraw this petition with liberty to urge all the pleas raised in the present petition at the appropriate stage in the trial court. Disposed of is withdrawn with liberty is paid for. Interim order stands vacated. Yes.
My lord, the discharge application was rejected. This is impugned in this case.
So your lordship may observe one sentence that the trial court will deal with this matter without being influenced by
I
this
can't say
rejection.
that, sir. Can't say. Yes.
Specialist item number 13.
None appears dismissed on prosecution.
Specialist item number 14.
None appears dismissed on prosecution.
Specialist item number 15.
None appears dismissed on prosecution.
Specialist item number 16.
Item number 16, may I please?
Yes.
My lord, I am appearing on behalf of my learned senior, Mr. Gautam Mukherjee, senior advocate. My lord, in this case, the petitioner number 3 and the opposite part number 2 are husband and wife. My lord, their marriage was solemnized on 26th of April 2011. And after living for some months peacefully and happily, due to some misunderstanding and dispute between the husband and wife, the opposite party number 2 wife left the house of her in-laws and went to her maternal house, my lord.
You served opposite party number 2. You don't seem to have served her yet in all these years.
My lord, the notice has been served as per my knowledge, but
Postal AD not yet received from opposite party number 2.
my lord.
This is more than 10 years old. Anyway, if according to you, there's a compromise, you can place that in before the court concerned. They'll pass appropriate orders.
My lord, actually,
if there is a compromise, the statements of both parties will be recorded by the court concerned and the case will be closed.
My lord, actually, the allegation that is section 498A, that is a non-compoundable offense, my lord.
But correct.
That is exactly why the petitioners have filed this present application invoking.
No. Now there are Supreme Court judgments which take care of all of that.
My lord.
You can't not serve the opposite party number 2, please. In the last 10 years,
my lord,
opposite party number 2 has remained unserved. Full stop. Permitting the petitioner, the basis for seeking quashing of the affair is that there is a compromise between the parties. Full stop. It will be open to the parties, if there is such a compromise, to have it recorded, have the statements recorded in the court below, in accordance with law. Accordingly, the petition is disposed of with the above observations. The interim order is vacated. Yes.
Specialist item 17.
None appears. Dismissed from prosecution.
Item number 18.
May I please?
Hello. I have challenged the complaint case itself, the proceeding in the complaint case.
Yes.
The husband has filed the complaint case against the wife for defamation.
Yes.
On my humble submission, the allegation is I reported his adulterous life, bigamous life, to his director through a legal notice. And that is what he says to be defamatory and a complaint under section 500. My humble submission, this will be covered by the exceptions 8 and 9 of 499.
That can be pointed out to the trial court, sir. You don't have to stay it here.
On the reading of the complaint itself, it is apparent.
Postal AD not received. No, you have not served the opposite side, sir. You say leaving it open to the petitioner to raise all the contentions raised in the present petition at the appropriate stage. The petition is disposed of. The interim order is vacated. Yes.
Item number 19. Item 19.
None appears dismissed on prosecution. The interim stay, all these matters, the interim stay is vacated. Communication should be sent to the concerned court.
Specialist item number 20.
None appears dismissed on prosecution. The interim order is vacated. Communication be sent to the concerned court.
Specialist item 21.
In this case, the petitioner's challenge on the ground that there is no marital relationship, there is no marriage. But in the between the 10 years from the last latest instruction, I have not. even filed. So I pray for next week.
No, no, no. We'll permit you to raise all these pleas at the appropriate stage, sir. Counsel the petitioners seeks leave to withdraw the present petition with liberty to urge all the pleas raised here at the appropriate stage before the trial court. Disposed of is withdrawn with liberty is straightforward. The interim order is vacated. A copy of this order be communicated to the judge concerned forthwith. All right.
Specialist item 22.
Your Madam, the case arises out of a complaint case, Madam. On this same day, the incident took place for which, Madam, the FIR was lodged and the complainant was arrested and subsequently was released on bail, Madam. Thereafter, Madam, this complaint case was filed and the allegation is that the incident took place in a public road, Madam.
Sorry?
In a public road, the incident took place, Madam.
Okay. What happened?
He has Madam, cited two witnesses in his complaint petition. Except the initial statement of the complainant and the statement of his wife, there is no other material available on record before the learned trial court to cognizance of the offence, my lord. All the offences, my lord, are summons case, my lord. 506, 294, 323, 34 I. Since I have taken, my lord, that because I have lost the FIR and he was arrested.
All this can be urged in the trial court, madam. We don't have to interfere. Counsel, the petitioner seeks leave to withdraw this petition with liberty to urge all the pleas raised here at the appropriate stage in the trial proceedings. Disposed of is withdrawn with liberty is paid for. The interim order is vacated. All right.
I may be pardoned, me lords. Item 14, I got disconnected. I was waiting for the matter to be called.
Yes, tell me, sir.
My lords, here, the two petitioners, my lords, they are named as accused, my lords, along with two others, my lords, in an FIR lodged by the opposite party number 2.
1 minute, sir. Yes, sir. Yes, Mr. Panda.
My lords. My lords, this opposite party number 2 is the branch manager, Sundargarh District Central Cooperative Bank Limited. He lodged an FIR to the effect, my lords, that 528 employees of a industrial concern, that is Orissa Industries Lathikata, had been sanctioned with loans amounting to 81,21,346 millions. And the present petitioners before your lordships had given assurances in letters that they would make deductions from the monthly salaries and remit it to the bank, my lords. The allegation in the FIR is that although money was being deducted, it was not being remitted to the bank, and therefore, my lords, it was alleged that these accused and two other officials were guilty of committing offences punishable under sections 406, 409, 418, 420, read with 34 IPC. The two petitioners before your lordship, they had approached for anticipatory bail and they were granted anticipatory bail by this honorable court. That in the event of arrest, they would be released on bail.
No, the only difficulty, Mr. Panda, is that there's no service of notice on this opposite party number 2.
Service of notice, my lords, requisites were filed, but it has to be now assumed that it is to be served because
no.
2012, my lords.
I know, but what does one do? Because there's no return of the AD card.
My lords, presumption is that after a month, my lords, the
No.
service is going to have been made. But would your lordship permit me to trace out the address of this OP number 2 and send fresh notice to him?
No, but what has happened? You were supposed to place and record copy of the memorandum of settlement reached between the parties.
Memorandum of settlement is with the bank, my lords. And the IU has filed charge sheet saying that up to 2003, my lords, deductions are there. And after that, there are no deductions. That is the allegation. That the government council can appraise your lordship, my lords.
No, you had made a statement which was recorded by this court on 10th April.
Yes, my lords.
2012 that the bank's dues were ultimately cleared by August 2007.
Yes, my lord. I have stated so in paragraph 4 also.
But you were to place those documents. You were to place and record the memorandum of settlement reached between the bank and you. That's the order.
Can your lordship give me some more time? I'll find out.
All right, Mr. Panda, learned counsel appearing to the petitioner seeks time to place and record the memorandum of settlement reached with the bank and also ascertain the correct present address of opposite party number 2. At his request, list on 24th June, interim order to continue. All right.
Can it be the last week of June?
24th June, sir.
Special list item number 23.
May I please, your lords? My lord, during pendence of this 482 application, petition number 2 is valid date. And your lordship have glanced to annex of 2 at page 13. Order of cognizance is under challenge, my lord. Cognizance taken under section 498/506 IPC. Meanwhile, my lord, matter has already been settled. And the opposite party number 2 has already been appeared and he has filed an affidavit. Your lordship have glanced to the affidavit filed by the OP number 2.
Copy of that affidavit has not been served. I request my senior to serve a copy. We will also assess
that
from the.
They will settle. Just show him the. All right. You see the opposite party number 2 has filed an affidavit dated 26th April 2012 stating that all the disputes between the parties have got settled and she has no objection to the criminal proceedings quashed by this court. Stop. That view of the matter, the application is allowed and GR case number 208 of 2008 corresponding to Daman Jodi PS case number 25 dated 9th April 2006 pending the court of the SDJM Koraput is hereby quashed. The petition is allowed to spread for. The copy of the order be sent to the concerned court forthwith.
Special list item 24.
24, my lord, this is a case filed for quashing of FIR under section 498A. In the meantime, both have filed the mutual divorce petition before the learned court below, and mutual divorce petition has been allowed.
Where is that?
Copy is not there. My
Who is a copy, sir? You can't just make a statement like this.
2 week time may be granted to file the order.
Counsel of the petitioner claims that divorce by mutual agreement has been, mutual consent has been already granted by the concerned court. He volunteers to, he seeks time to produce a copy of the said order. Has the opposite party number 2 been served, sir?
Opposite party number 2 is not, has not been appeared.
They have annexed an affidavit filed by the opposite party number 2, madam, but.
I see. Compromise petition.
Yes.
Let's see what that is. Deepali Sahu. It's all in Odia.
That says, madam, that they have compromised.
Compromised. All right. In view of the affidavit filed by opposite party number 2, a copy of which is connection 3 series, and the compromise petition signed by the parties. This court quashes the FIR in connection with Baleshwar Town PS case number 144 of 2012 corresponding to CT case number 930 of 2012 pending the court of the learned SDJM Baleshwar. This petition is disposed of. Copy of the order be sent forthwith to the court. That's it.
Specialist item 25.
May I please your lordship? I am appearing to VC, my lord.
Yes.
Well, my lord, an application for, was filed for discharge of the accused person for alleged commission of offence under section 408 and 420 of the Indian Penal Code, my lord. But I have instruction that during pendency of this application, the complainant along with 3 witnesses have already died.
All right. Then nothing remains, sir.
Well,
complainant is died.
The complainant, the informant, my lord, who has lost the affair, has died, my lord.
Okay.
And also the 2 or 3 witnesses have also, in the meantime, have also died, my lord.
Then what remains, sir? Then don't press this petition right now. On account of the subsequent developments, the question, the counsel, the petitioner does not press the petition at this stage, with liberty to urge all the contentions if required at the appropriate stage. Disposed of is not pressed. All right.
Please. Item number 26.
May I please, my lord? May I please, my lord?
Yes, yes.
But the petitioner is a police officer. He was an investigating officer in connection with another case. And it is alleged that the sanction has not been obtained before protest petition was filed. And the case was, manual kindly have a glance, para 4, the SP Ganjam and the STPO had inquired and found that it is a false case and the case was final report. Subsequently, the informant has filed protest petition. The learned STJM took cognizance of the offences. I have raised all the points under section 197 sanction is necessary, but the action taken by the accused is that the discharge of police duty. And there is a case and counter case. And there is a counter case in which in GR case number 50 of 2013, the present petitioner was the investigating officer. And in GR case number 52 by 2003, the informant is the accused. And the present petitioner is the accused in GR case to present case 51 of 2003. I have filed petition.
Have you served the other side, sir?
My friend Mr. Sarangi.
State is the main party. I am for the informant. Here the allegation is actually in the guise of, instead of registering the case, she called the informant, who is a lady, and tried to misbehave with her and wanted that she should be entertained so that the case will be registered. I called the villagers, he was got hold of. He admitted that thereafter this counter case, what he calls a counter case, is a case for his defense. When the villagers got hold of because of his misdeeds as assaulted, and this can never form part of the official duty, so as to attract 197. That's what the learned court has said and refused 197 and took cognizance.
Correct.
He is now 65-year-old. He was a SI at the time of occurrence. So
Yes,
he has
yes.
retired in the meantime.
Yes. There's no question of sanction also, sir, now?
Yes.
That also goes.
That also goes.
Well, now, but at the time of occurrence, sanction is necessary.
Yeah. Now, you say now that the petitioner is retired from service, the point urged does not even survive for consideration. Consequently, the court is not inclined to entertain the present petition. The interim order is vacated, the petition is dismissed.
But I pray one thing I will raise, but at the time.
Not this point. If you have other, you say other than the point raised in the present petition, it will be open to the petitioner to raise all other differences.
But at the time of occurrence.
At the time of the trial. Yes.
But I may pardon, at the time of occurrence, sanction is necessary.
Anyway, that you raise. All right.
Not pressed,
Case
not pressed.
targeted, my lord.
All
So
right.
many
Counsel,
years
the petitioner does not wish to press this petition at this stage. Disposed of is not pressed.
With liberty to raise all the points.
With liberty to raise all the points.
My lords, now it has elapsed. Your lordship may target it so that it can be finished.
The trial court is requested to expedite the case and complete it within a period of 6 months from today.
Order be
Copy of the order be communicated to the trial court forthwith.
Right.
We continue after lunch. after the break benches. Huh? Okay.
Supplementary list for orders item number 1.
May I please, Your Lordship? I am for the virtual mode, my lord.
Yes,
My
yes.
lord, this application is filed for recalling order data 6/8/2019, my lord. My lord, on the ground that the prayer which has been made in the REIT application. has
So
not
this is
been-
actually a review petition. It's not a recall. It's a
My lord-
review petition without any application for delay.
My lord, if they not, my lord, my respectful submission that the case has been disposed of considering the another aspects which is not in the prayer and my REIT application. My lord, my REIT application and prayer is something different.
No, Mr. Mahapatra, it is a review. You are essentially seeking review of the order. So it has to be, your application has to accompany a petition for condonation of delay. And the REIT court has decided the matter relying upon a division bench decision squarely covering your case.
No, my lord,
2011 Orissa.
no, my lord, that is the, my lord, lordships look to the prayer of the REIT application.
No. First of all, get over the technicality.
That's
Then
right.
we will go
It's a review petition, sir.
Yes.
You have to file an application for delay. You withdraw this application.
Yes, my lord, liberty to file a review application.
Yes, yes. Counsel to the petitioner seeks leave to withdraw this application with liberty to file a proper application in accordance with law.
Item number 2.
Dismisses withdrawn with liberty.
May I please, Your Lordship?
Right.
300 to 201. I am on bail during trial. After appeal, I am in custody. Now, my earlier application was rejected by Your Lordship 4 years before. Here, only, even though it's a cooked up case, and the lacunas have been detected by the learned court, but the benefit, instead of giving me the benefit, he says it cannot be given to the accused because of the lacuna of the investigation, no evidence is there, and rather the PW4, who is the brother of the deceased, he works in the SP office as a constable. For that reason, it's a cooked up story. Now the only witness is PW9, the eyewitness. Before police, he never named anybody, only said some unknown person.
How many years have you?
Now, date of judgment is 18, March 18. Now 4 years already passed. During trial for some time, but I was on bail after.
This is a direct evidence case, sir.
That I humbly submit, Milords. It's a statement made in court, not before the police, that has been confronted to the IO. Milords, may I point out the relevant person?
That has been considered, and your bail application was rejected. That has been considered already.
I was not there, so I cannot say what actually transpired, Milords.
What is the same circumstance? Only
Yes.
time. Only 3 years.
You renew it after some time.
Milords.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to renew the prayer after some time. Disposed of is withdrawn with liberty is paid for.
Orders item number 3.
Obviously.
Item number 3, my lord, I am appearing in the third item. There are
Yes.
2-3 review applications. I am appearing in review application 64 of 2021.
Right.
My lord, review application 9 of 21 state is the petitioner.
Yes. Even 64. 64 also is Union of India.
Union of India.
Yes.
Tell us, sir.
My alternate may submit for the first item because nobody submitted anything, that is why I submitted.
I think notice has not been issued to the opposite parties. They are
Oh. No, do we have to issue notice? What is the point?
My lord, what has happened, my lord? Due to the order of this honorable court, we are unable to recover a huge revenue from the hearing officer. That your lordship may kindly have a glance over para 17 of the review petition.
What is that revenue? 25,000.
No, my lord. 2,76,650 and 97,000, more than 3 lakhs. It appears.
What's the order passed by the court?
That is at
He
page.
retired from service.
Yes, my lord.
So just
Yes.
leave it be, sir. No ground made out for review. The review petition is dismissed. The delay is condoned. What about the remaining? What is the other review, CM, APL and all? What is this CM,
It is a different matter altogether. Why it is listed along with it, I don't understand.
What is this to do with that? I don't know. They've just connected everything.
No, it is, all these are not connected.
I think these are not connected matters. This is state review petition. Your lordship has already rejected it. Others can be segregated. Because
what is the CMAPL? Let's see that.
CMAPL is for condonation of that is for restoration.
Who's appearing in CMAPL?
I am appearing for the last case, my lord.
No, the CMAPL. Anyone appearing in CMAPL? One minute.
CMAPL number 533 of 2019.
Let's just see that.
Airport Authority.
No, none appears. Mr. Padi, are you there? He's there. Mr. PK Padi is there.
Mr. Padi.
Yes, my lord.
So the CMAPL.
Yes, it was dismissed.
Sir, nothing has happened in this matter, sir.
I heard that this petitioner is died. Dilip Mahapatra, Telugu Mahapatra, retired IPS, he's died.
Then don't press this. That
Yes, my lord.
Mr. Padi is informed, states and instructions that respondent one has
Yes, ma'am.
passed away. In that view of the matter, there's no need to recall the order dated 25 July 2019.
Yes.
The application is accordingly dismissed. Then review petition 340, Kabiraj Behra.
70 days delay.
All right.
That is the merit. Similar persons have been granted relief.
21/11/2019. Where is that order? Kabiraj Behra. But you came late, sir.
My lord.
You said delays condoned, no ground made out for review, dismissed. All right.
CMAPL 273 of 2020.
Who's appearing in CMAPL 273?
Mr. Vishwabihari Mohanty.
VB Mohanty.
No one appeared. There is also
Defects not removed. Again, say none appears for the applicant, dismissed and non-constitutional. All right.
Review pet 64 of 2021.
May I please, my lords? My lord, 64 of 2021 has been preferred by Union of India.
Right.
There has been a delay of 700 days.
That's enough, sir. It's a delay of 700 days in filing the review petition, which is not satisfactorily explained. The delay application, IA 81 of 21 is dismissed. According to the review petition is dismissed.
May I pray one thing, my lord?
Yes.
In CMAPL 533 of 2019, not that he expired. Can clerkship may defer to some other day after getting instruction, clerkship may dispute.
No, sir. Let's not go back there, sir. It's okay.
One matter.
Yes.
CMAPL 5 of 2022.
My lord, in this case, 748 days delay, my lord.
There's a delay of 740 days, which is unexplained. IA number 3 of 2022 is accordingly dismissed. Accordingly, the same APL is dismissed. All right.
yes.
Right, sir. Thank you. All right. Good.
Sadev, sir. My lord, may I make a
Good
mention?
afternoon.
Yes. My lord,
Yes,
with your
yes.
lordship's kind permission, may I make a mention? My lord, I moved an urgent application in a pending writ petition where my lords had passed an order. This pertains to, my lord, fixation of ASP price by the respondents for a low grade iron ore. My lord, for 1.5 years, they have not fixed it. The consequences, my lord, I have to pay a higher amount and I may be in breach of my MDPA. So I'm requesting if my lords could kindly have it next week, I'll be grateful.
But you'll have to be for the assigned bench. Anyway.
Yes, it will be to the, yes, my lord, to the.
It's modification.
On Tuesday.
My lord, it's a modification order of an order passed by my lord. So I leave it to my lords if it can come up before my lord or whatever. I leave it to you.
My lord.
What is the number of the application?
Case.
My lord, it's 5314 of 2022.
IA.
Yes, sir. My lord, 5314 of 2022 and writ petition 19616 of 21.
Yes, yes.
So please ask your instructing counsel to give a memo or slip here.
Yes, my lord.
Then I'll ask the DR to place it before me and then we'll fix it most probably for Tuesday or Wednesday.
I'm so deeply grateful, my lord.
All right.
My lord, that review petition copy may be solved because the copy is not available.
It's not a review, it's an IA.
IA petition copy.
We'll have to serve a copy on Mr. Manti here.
Yes, my lord.
They become the one.
My lord, you have already filed. I'll give a copy, my
lord. All right.
I'm so deeply grateful, my lord.
All right.
My lord, I may be pardoned, my lord. GCRLA 5 of 2008 may be listed because
Since long it is pending, it may be listed, government criminal appeal.
That will come up, I think. You just take the memo. It will come up because I'm hearing all old criminal appeals.
On Thursday, your lordship is
That's
taking
right.
up. Yes.
That's right.
Next Thursday. This is government criminal appeal 5 of 2008.
GCRLA. 5 of 2008. All right.
Yeah, from the list. I have filed 3 memo. I have been settled our orders of attachment. So
Faceless assessment.
can I
Tuesday?
Wednesday?
Wednesday. All right. Wednesday. All right.
What's up? Supplementary list for orders item number 1.
Why don't you serve copies on Mr. Mahapatra or Satpati or?
I have solved that.
All right. All right.
Please, my lord.
Yes.
This MAPL is for restoration of the writ petition, which was dismissed because of my brief being misplaced, my lords. My lords granted liberty by order number 33.
All right.
To file
The reason stated, the application is allowed and the order dated so and so is recalled and writ petition 8361 of 2010 is restored to file. Now, what is the matter about?
Lords, here what has happened is the OSFC had a policy, my lords.
So we'll take it up in the roster bench then.
My lords, can it be taken up a week after? That's what I am praying.
All right.
And
List
with
on-
that, my lords, can the records be called for of WPC number 3884 of 2009
All right.
and 2636 of 2009? Both were disposed of on 9/4/2010.
Okay. The records of those two writ petitions to be called for the next date. List on. 11th May, sir.
My lords.
Item number 2.
Wait, please, my lords. Sheer desperation, my lords, the association approaches your lordships, my lords. The facts are like this. The NALCO was set up, my lord, the NALCO, my lords, aluminum company was set up in Angul with the assurance that the coal will be supplied by MCL for, my lords, running the unit, my lords. Now, my lords, MCL had earlier, once there was a disruption in the my lords, supply of coal, my lords, your lordships have intervened in 2008, and then, my lords, the coal supply was restored, and NALCO, my lords. The difficulty is now, my lords, we have only, the NALCO, our industry has only 2-3 days stock left of coal.
How come NALCO is not before us? You all of you are.
My lords, we are the association. If NALCO goes, my lords, we will.
No, but why isn't NALCO coming forward?
I would not know, my lords, but
why not? Are they a party here?
No, NALCO.
You should make them a party. We should know why they are not coming forward.
I will implead them immediately as pro forma opposite parties.
All right.
And also, my lords, lordship, my lords, we have only 2-3 days stock. The difficulty is this, my lord. At least 4 rakes have to be given the sanctioned by railways for NALCO for transportation. We have stock up till only Sunday.
But why is NALCO not coming forward? This is what is surprising.
This is the officers association.
I know.
It is our, my lord, it is our unit. It is our unit, our services, our livelihood.
I don't like the livelihood may be at stake, but even then your salaries will not be stopped.
No, it's not a question of the loss, the sheer loss to the public exchequer, and once the pots cool down,
which is what's surprising. So why did the NALCO wait till the last minute? They haven't even come forward. That's a bit surprising.
This is just a issue that has been brought before your lords, brought to your lordship's notice, my lord. This is as much as the cause of the court in public interest as much as the cause of the petitioners, my lords here. I would only pray and beseech your lordship to intervene in some form, my lords. We have served copy on the Central Government Council, who nowadays the government's new policy, they are appearing for the railways. I have served in all matters. I have served copy on Mr. Paddy, my lords. And let the direction, the interim direction, you should at least, my lords, 4
Who appears usually for NALCO?
My lords?
Who usually appears for NALCO?
My lords, my young friend, Ms. Ratha, is also here.
I do appear in such matters, but I
If your lordship wants or not, immediately I'll serve a copy on.
All right, you said the oral request of Mr. Palit. National Aluminium Company Limited, bracket NALCO, is arraigned as opposite party number 6.
And also I am impleading railways, my lords. Government of
And on
India.
this IA, you say,
Hey. Pardon me, but in a hurry, my lords, I could not stick to the schedule. Physical copies.
this IA number to be numbered, you say the reason stated the application is allowed and the following parties are added as opposite parties 6, 7 and 8. So NALCO will be 9.
Additional affidavit be also taken on record. So given detailed breakups, my lords.
The
In the
petitioner has
interim,
also
my lords-
filed an additional affidavit which is
Right.
taken on record. You just say notice. This Amir Ratha is requested to accept notice on behalf of NALCO and obtain instructions. Mr. Pari, you are there for Union of India.
Yes, my lord. Yes. Yes, my lord.
Then who will appear for Mahanadi Coalfields, Bharatpur Mines?
Mahanadi Coalfields, they have a panel. I offered to Mr. Mahanti, but he said once notice is issued, somebody will be allotted with the brief.
All right. Mr. Manti, DK Manti accepts notice for opposite party number 5. And then there's one Mr. Mishra who appears for East Coast Railway, I think.
East Coast Railways also, but probably Mr. Padi would appear.
Mr.
Padi would also
Mr.
appear.
PK Pari
for
accepts notice for 6, 7 and 8 as well.
My lord, so far as opposite party now 5 is concerned, I think no notice be issued is not necessary. Party state government,
Chief
secretary. No notice may be issued
For
as
the
of now.
time being, for the time
being, no notice may be
Because
issued.
collector would be there to oversee the arrangement.
Collector
also.
is not a party, but chief secretary he has included as a party.
All right.
My lords, in the infringement, my lords, only since Mr.
I think we
Padi.
delete opposite party number 5 then.
My lords,
Should we delete?
Lakshmi delete opposite party number.
Yes.
All right. The oral request of
Lakshmi
Mr.
delete.
Palit, opposite party number 5 is deleted from the area of parties. All right. The consolidated cause list, the cause title be filed
By Monday.
before the next date. Yeah.
By Monday. My lords, up to Sunday we have this stock.
Monday, we'll call it on Monday.
No, we'll shut down on Monday.
What to do? You're coming on a Friday. You can't say, what do you do?
The problem can be the coal is lying in MCL, the coal is lying in MCL. Problem is transportation. If one of Mr. Padi is here, if Mr. Padi is here, only 4 rakes be allocated by railways today, man, it can be, transportation can be done only 10 kilometers from Bharatpur colliery.
Consider
The unit, it's a question of the unit shutting down. Man.
let matter be come on Monday. Let's see.
No, I will. It's a question of just to survive, man. To survive.
Okay. In the meanwhile, if a request is made by NALCO to the East Coast Railway to allocate 4 rakes to transport coal from the Bharatpur mines, Mahanadi Coalfields Limited, of Mahanadi Coalfields Limited to the plant at Angul, that request should be considered by the East Coast Railway on priority basis.
Deeply.
All right. All right.
Item number 3.
Urgent copy of your lordship's order.
right.
Urgent certificate.
My lord may reflect if there is no legal impediment.
That's all right, sir. You'll tell us on Monday. We're listing it on Monday. Yes.
Item number 3.
Your lordships, we are basically an industrial enterprise. We producing power. Your lordships, we need water, and the subject matter of water is under entry 17, list 2.
No,
And the
this
state-
is an IA that you filed.
Lordships, before I just thought before I could just
Yes.
say this particular entry is covered by our Orissa Irrigation Act 1959 and rules. Your
That's before a larger bench.
Lordship. No, I'm not on that issue, your lordships. The thing is, I get a water only when I get a permission. That's a license, your lordships. Your lordships, the relevant, just for your lordship's convenience, I've just compiled the relevant provisions.
See, we are sitting as a special bench today you tell us notice should go in this IA, right?
No. Lordship, basically this is about that compulsory, they made this one-time water conservation fund. They've made it compulsory on me. Your Lordships, in fact, in the Bhushan judgment, where they had only made a request, Your Lordships have already held that this cannot be a compulsory levy. But in our case, when we are about to have a renewal, this is a statutory contract. When we are having a renewal, they are now introduced by exercising powers under Article 162 that you have to now pay that.
We just issue notice on this amendment application.
Your Lordships.
Yes, my lord.
Let him take notice and take instructions.
Similar order has already been passed, Your Lordships. We are already
But I
under.
have to take instruction, my lord, because there is a question of revenue matter. They are now
Your
challenging
Lordships,
the clause
that's why Your
28.
Lordships, that's why I wanted to show Your Lordships that Your Lordships will kindly look at that IA, that's an F.
We'll have to give him time for instructions.
Your Lordships, I've served them copy beforehand, Your Lordships.
No, it's okay. We'll call it next week.
Your Lordships, no, if I don't sign the agreement today, do this my last day, my power plant will shut down. If I should be allowed, Your Lordships, I'm already covered by an interim.
You sign under protest.
Your Lordship, I will have to pay that, otherwise they will not sign it. They have made it a man. Your Lordship,
so you paid under protest then?
Yes,
Your Lordship, is already an order of this court. In my previous agreement, this portion has been stayed, Your Lordships. They know about that stay. Still, they are compelling me to pay this.
That stay order which my learned sister is relying upon, that is of the year 2013, what I prima facie find. And this is a subsequent
agreement. That's 2017, we have a stay order. That's there on record, Your Lordships. 2017, Your Lordships.
But I would pray.
Your Lordships, let me tell that without Your Lordships, it's a demand without a legislation, Your Lordships.
But in fact, just to assist Your Lordship, this honorable court has already interfered in those matters.
Your Lordships,
fund has been stayed by this honorable court.
Your Lordships, in NALCO's matter also there is a stay operating. In GMR matter also the stay is operating. In Bhushan matter also the stay was operating, Your Lordships. But still they are making this order. Your Lordships, 31/7/2017. That this same clause has already been stayed. Now when the second renewal, they again are imposing this. And Your Lordships, this is a statutory agreement. Form K does not have this. The entire statute does not have this levy. And in Your Lordships, in their counter, they say that this is not a tax.
All right. Why don't you postpone the date of signing the agreement at least? Give them time to sign the agreement.
That is Your Lordship.
Till we take it up next, let you not insist on signing the agreement.
Yes.
And they should be allowed to consume without.
Now, without agreement, how can you consume the water?
That's it. Then I will shut down the power plant.
Otherwise, you pay the amount under protest. You deposit the amount under protest.
We supply power to Orissa, Your Lordships.
That is
There's
okay.
a clause under this contract.
This clause, you have challenged it.
No, continue supplying the water. We just postpone the date of the agreement being signed.
Yes.
Ah.
Now, but without the agreement, I think what I...
No, so you don't stop the supply of water.
But without the agreement,
that's right. So either you say that you will not shut down the supply of water, or we say that they can sign the agreement without insisting on payment of the money.
Lordship may say that the postpone the agreement.
All right. You say notice. He accepts notice and seeks time for instructions. Considering that the deadline for signing the agreement was today, a direction is issued that the date of the agreement being signed will be postponed till further orders from this court. And in the meanwhile, the supply of water will not be stopped, but will be continued on the existing terms.
Lordships, the only thing I wanted to insist is we are actually reducing our allocation. So we should be we have 24 cubic. So we should be considered with 20 cubic. Because they would still charge me for 24 cubic, even if I would be.
I cannot answer all these disputed questions.
We'll only take it up next week.
I will file a counter to this.
That's right.
Their counter is there on record, Your Lordships.
No, the subsequent prayer you want to incorporate and the challenge to this clause number 28, those things have to be replied by me.
List on 27th.
Lordships.
27th we take it up.
27th April.
Yeah.
Okay.
Item number 4.
May it please the Lordship. My Lord, I am appearing virtually, my Lord.
Yes.
My Lord, in this case, the assessment order is passed and notice of assessment is issued after the expiry or death of the assessee, your lordship. So on that ground, the petition is filed saying that the notices and the assessment orders are nullity because it is passed against a person who is dead. The proceeding is started after his death.
All these matters are coming up. Have you filed a reply?
Yes, my lord.
He's already filed a reply, my lord. Person expired, my lord, on 15th April 2018, and the notices were issued.
We'll just hear it on some other days. We'll hear it on some other day. List on 6 July, interim order to continue.
Grateful, my lord.
The order may be uploaded in course of the day.
Yes, yes.
Interim. Order.
and other duties, etc. So here also the rates are fixed after taking into account. Yes, quoted. Then kindly come to page 84, clause 2.16. The notice inviting tender instructions to tenderer, general conditions of contract, detailed call notice, special contract specification, schedule of quantities, along with printed conditions of PWD form number so and so, approved drawings, time schedule, and the rate together with the letter of awarding the contract will form part of the contract. In case of conflict between any of the provisions, the same to be got clarified by the tenderer before submission of the tender. If such conflicts arise after the tenders are opened, the decision of the Chief Engineer, Rural Works Department shall be final. Then your Lordship will see page 85, clause 3.3. The contract comprises the construction, completion, and maintenance of the works, and except insofar as the contract otherwise provided of the provisions of labor, materials, and construction plant, temporary work, etc., everything, whether of a temporary or permanent nature, required in and for such construction, completion, and subsequent maintenance for a period of 24 months. Then clause B, subclause B of clause 3.4. No claim shall be entertained against the department on account of any increase in the railway or road freight prices of cement, steel, petrol, coal, fuel, oil, lubricants, explosives, and other materials or commodities, labor charges during the course of construction or after tender for this work, except for such extra cost, however, an escalation clause is enclosed separately. Now kindly come, my lord, to clause 3.20 on page 87. The rates in the tender will be deemed to include cost of all materials, including loading, unloading, loads, lifts, taxes, royalties, etc., and other charges, whether materials are issued the department or arranged from the other sources of the contract. Then your lordship will come to clause 3.48, page 90. No, before that, sir, clause 3.27 on the same page, 87. the concerned executive engineer shall make any variation of the form, quality, or quantity of the work or any part thereof that may, in his opinion, be necessary, and for that purpose or any other reason, it shall be, in his opinion, be desirable. If due to such alteration or addition, any item or items of works are to be executed which are not specifically covered by the contract, then the same may be taken up departmentally through job work agreements with the same contractor or separate piece workers, or through muster rolls at the prevailing schedule of rates or rates approved by the chief engineer, rural works department. So this is the only clause which contemplates schedule of rates. Otherwise, in the entire contract, there is no reference to schedule. And the schedule of rates is relevant only in respect of this extra work. Then your lordship will come to on page 90. Clause 3.48. Any authority by the engineer in charge for any alteration or addition in or to the work is not to vitiate contract, but addition, omissions, alteration, and substitutions made in carrying out the work are to be measured and valued and certified by the engineer and added to or deducted from the amount of the contract as the case may be at approved rates. So the point now, sir, is this. Then your lordship will see page 102.
No, but Mr. Nafde, what is the error apparent on the face of the record?
The error is this, that the impute judgment proceeds on an assumption that a change in the tax regime makes an impact on the rates which are payable to. There is no provision in the contract. There is no law which says such a thing. Now, therefore, this is something which is missed out. Maybe it is our mistake. The point is this, that
yes,
your lordships have recognized that even a lawyer's mistake is a good ground for review. I have quoted that Supreme Court judgment at page 41, para 90 of that judgment. Now, therefore, your lordship sees the entire matter proceeded on an assumption that a change in the tax regime makes a change in the rates payable to me. Where is such contract? There is no such clause. So kindly see the last clause, page 102. And that is error apparent on the face of the record.
That might be an additional ground that you may urge when you assail the judgment.
So it's a question of jurisdiction. Your lordship sees that the whole debate or controversy started when they issued the office memorandum. The office memorandum proceeds on an assumption since now GST has come into force in 2017. Therefore, GST provisions make an impact on the contractual rates, contractual approved rates. Where is the warrant for that? See, there is no authority of law with the state government to change the rates. Now, this is the point. It goes to the root of the matter.
Yes.
Which is not considered. That is point number one. So the second point, the memorandum proceeds on an assumption that the schedule of rates of 2014 will apply to the contract. Now, if your lordships have a look at the relevant dates, the date is 14th of January 2014 is my day of my contract. 15th of January, I stand corrected. The schedule of rates is notified on 10th of November 2014. Now, therefore, their office memorandum proceeds on a document which has no relevance. These are two errors which are on the face of the record or for sufficient reason, as the apex court says. And therefore, in my respectful submission, this requires reconsideration. This is not I'm quite conscious of the fact that this is not an appeal. This is not re-hearing the original writ petition, but a ground which is missed out both by the lawyers as well as by the court. And therefore, I request your lordship to allow this review petition and re-hear the matter. I'm grateful.
Yes, who's
I'm appearing for I'll counter appearing.
counter? No. You'll just have to see whether the review is admissible at all or not. This is Rautre, because you dealt with it quite elaborately.
If your lordship will issue, because he has prayed for setting aside the judgment.
No, it's a review of the judgment he's seeking.
But prayer is that to set aside the judgment.
No, that's what it means.
Yes.
Review means recall and review the judgment.
That event, your lordship may issue notice. If your lordship finds any prima facie case in favor of the petitioner, then notice may be issued. I will ask the opposite parties to file counter.
No. This is not, review is not meant for Justice Rautre. I thought we dealt with this elaborately.
Sir, I need a in-depth further study in view of the submissions made by Mr. Nefade.
All right. Mr. Nafde, then we'll just examine this more and we'll list it on another Friday, if you do not mind.
If your lordship can indicate the date so that I keep myself free.
Can it be 13th May, sir?
Very well.
All right.
Grateful.
All right. List on 13th May. All right.
Orders item number 2.
Please, your lordship. Lords, the petitioner has renewed his prayer for bail, which your lordship was pleased to reject by
Yes.
order 4/10/2021.
By one exhaustive order.
Yes. Paragraph 9 is your lordship's reasonings, my lords.
Yes.
Thereafter, my lords, your lordship directed the matter to be set up for hearing in the second week of February. Now, what has happened, my lords, is this. Your lordship refused bail, my lords, on 4/10/2021. Now, I'll draw your lordship's attention to page 5 of my interim application. By the refusal of bail was on the ground that basically there was an objection by the police officers and that there are some criminal antecedents, which I tried to place before your lordships that they were not antecedents, but 3 of them were subsequents, while 1 was a reopening of a final form. Now, the very same police, my lords, was pleased to allow me to go on parole by order dated 3/11/2021, my lords. They recommended my parole and I was released for 14 days. Then, my lords may see page 7. Again, I was given special furlough leave for 10 days, my lords. Order dated 8/12/2021. Then your lordship may see page 9. By letter dated 17/12/2021 of the superintendent, my lords, I have been given special furlough leave for a period of 90 days. And
Yes.
this has again been extended on 16/3/2022 for another 60 days, my lords. Lords, if I am eligible for parole, if the police has no...
So you're still on parole, sir. So on 16th March, you were given 60 days.
Yes.
You're still on parole.
I am on parole, but I am seeking bail, my lords.
No, but let the parole be successfully completed.
Lords, there are several cases where accused petition appellants being on parole have been granted bail by this court.
It's furlough. It's furlough release.
Yes, these
As
are
the rule-
furlough release.
Yes, prison rules. As per the rules provided with Orissa prison rules. That
He's
the
been
right-
released on furlough, is it?
Yes, furlough.
Oh, I see. So we can keep this pending. Let us hope that the appeal is taken up.
Yes, the paperwork is ready.
My lords, the appeal cannot be taken up. It's an appeal of the year 2019. There are 5 appellants, my lords.
Huh.
2 of them are on bail, my lords.
Yes.
Counsel for one of the appellants has since been elevated, my lords.
Okay. So what? They will engage another person.
My lords, taking up the matter is difficult. This is an appeal of the year 2019, my lords. I am in custody since 2014. If I am eligible for furlough, my lords, why should I not be given bail, my lords? That is the fundamental question I am asking.
It is speculation on the personal honesty. This violation is speculative.
If the police doesn't have any objection to my remaining on furlough, my lords, and that too for extended periods, my lords, why should your lordship refuse bail to me if I am not violating any conditions of furlough? Why doesn't your lordship call for a report from the police as to my behavior during furlough?
Considering the entire submission, your lordship has been pleased to reject the bail prayer just on 4th October 2021. Exhaustive order.
I don't dispute that. But
Then
the
furlough
appeal
release
heard in the second.
furlough release altogether different thing, boss. Furlough is the right of the prisoner. Yes.
No, Mr. Panda, I think the point Mr. Katke is making is between October and now, the only change circumstance is that some more months have passed by, that's all. And maybe the second circumstance which you are urging that you have come out on parole, furlough.
Yes, my lords.
These are the only two circumstances that have
Let a
changed.
report be called for as to my behavior during this period.
I hope you have no reason to express any concern. I'm sure your behavior is the best.
No, my lords, it is appropriate that the same police who objected to my release on bail, if they have no objection to my being on furlough, my lord.
No, he can't object. He cannot raise an objection to the furlough release.
The police has no say in the furlough part, no?
Furlough, police doesn't have to say.
My lord, your lordship may look at page 6 again of one of the orders. Conditions of release. Conditions of release, your lordship may look at condition 2, condition 3, condition 4. All these, my lords, they require me to have, unless there is a report of the police about my good behavior, how can my furlough be extended from time to time? Mr. Katkia makes statements, but I am sure, my lords, that this is not supported by any decision either of the apex court or of the dishonorable court, my lords. If there is such a decision, let him cite the decision, your lordship.
There is distinction between bail, parole, furlough. I did not say.
Yesterday night, I read the entire law relating to furlough and parole. I never saw such a thing. I am sorry, my lords. Let him cite a decision.
No, bail cannot be equated with furlough.
No, bail cannot be. My submission is this. If I can be granted release on furlough, why should my application for bail be refused? That is the simple question.
That cannot be right for release on bail. That
I am only putting the simple question before your lordship. When I am in custody since 2014, my lords.
Anyway, what we'll do is when does the furlough come to an end? We'll take this bail soon after that.
My lords, after 16.3, it has been extended 60 days by a general order.
That's right. So we'll take it up sometime just before the vacation ends. We'll take it up on 13th May. Meanwhile, you give us a report.
A copy of the interim application may be sought.
All right. Copy of the application is served on Mr. Katya. You are for the complainant.
I'm the importer.
Sorry?
Complainant.
Complainant. That's all. You also. You can file an affidavit, whatever you want to. All right. List on 13th May. Right.
Your Lordship, I am for the CRLA number 780/19. Your Lordship,
Yes.
I filed for a condonation of delay, Your Lordship, of 64 days.
Yeah, that can be allowed. That 1709 of 19. The reason stated the application for delay is condoned. I'll allow the delay is condoned. Right.
I am also for the sub-item number 4, my lord. Sub-item number 4, that delay condone, my lord. Condonation of delay, my lord.
All right. That also.
Your lordship may see. Your lordship fixes the matter for hearing. Connected appeals delay has not been followed.
All right. Anyway, one benefit to your co-accused.
No benefit to me, my lords.
Not yet. All right.
Supplementary list for orders, item number 1.
This case was allowed in part, my lord, by judgment dated 15/12/21. My lord, while confirming the order of punishment so far reduction of pension is concerned, directed for payment of gratuity, but because there was no time fixation, my lord, till date this old person is not
All
getting.
right, all right. The
That's
only
the difficulty.
modification made to the order dated
15/12/21.
15/12/2021 is that the amounts payable to the petitioner in terms of the said judgment will be paid within the period of 8 weeks from today.
Obliged. May I pray, my lord, the accrued interest, they are also under the law, they are bound.
Along with
May I add
whatever
that?
interest is due to the petitioner. Right.
Yes, my lord, I add that so that they will again.
All
old
right.
person. Obliged.
Okay.
Item number 2.
Items 2, 3, and 4, my lords. They're the same, my lords. I filed an IA.
Yes.
For recalling of my lord's order dated 24/11/2021. In which your lordships are kind enough to grant liberty to the petitioner to file an application for revival of the present petition if cause of action survives.
Correct.
So all these matters relate to disbursement of principal amount along with interest, my lords. That's the first one. My humble prayer, my lord, without taking your lordship to those factual details, your lordship may permit me to make a representation to the Principal Commissioner of Income Tax, Bhubaneswar 1, Bhubaneswar, my lords, for all these 3 applications, my lord, and stating my grievances. And my only humble prayer would be that let him give me a chance of personal hearing so that I can produce my TDS papers and other papers and let him take a decision within a particular period of time.
All right.
So far the first one is concerned, it relates to the principal amount and interest, and the other 2 is only interest.
All right. The petitioner is permitted to make a representation to the principal commissioner, principal chief commissioner.
No, well, Principal Commissioner of Income Tax, Bhubaneswar 1, my lords.
Bhubaneswar 1, in respect of the claim for principal and interest in writ petition civil 11393 of 2016 and interest in respect of writ petition civil 11395 and 397 of 2016, and its representation is made not later than 16th May 2022. It shall be examined by the PCIT, and after hearing the petitioner, a reasoned order shall be passed thereon not later than 18 July 2022. And we communicated the petitioner not later than 20 July 2020.
And if any amount is due, let him also disburse that amount.
Yeah. If any amount is found due, it will obviously get disbursed to the petitioner. That's right. If any amount is found due, it shall be disbursed to the petitioner in accordance with law within a further period of 4 weeks thereafter.
Much obliged.
That's right. The applications are disposed of.
Your lordship allows the IA and disposes of.
Disposed of them.
Greatly obliged.
Right.
Item number 5.
Mr. Rai.
Item 5, supplementary list.
Oh, mention the appearance of Mr. Satyajit. I think his appearance is to be shown, is it?
No, it is not shown.
Extension of time. There he is. Yeah. Yes, Mr. Mishra. 3505.
Unmute your system. You are not audible, Mr. Mishra.
He needs 8 weeks time for extension. Extension of 8 weeks to complete. All right. For the reason stated therein, the application is allowed and the time for completion of the adjudication proceedings is extended by 8 weeks from today. The application is disposed of.
Supplementary list, item number 6.
May I please, let's say. Let's say my limited prayer before, let's say that I have already deposited 10 lakhs amount, substantial amount of the demand, but my RC has not been restored because of the full non-payment of full amount. So it may be restored and I may be permitted to deposit all other amounts in installment, let's say.
In installments?
Yes, let's say. Only 6 months. Mr. Chimanka is there.
Yes, Mr. Chimanka.
Since December 2020, my RC has been cancelled. So already I have paid 10 lakhs and lordship at pay 7. I have already deposited substantial amount.
Let him pay the full amount, only then the portal can be reopened.
No, she says she wants installments to pay the full amount.
I admit my liability.
But if in the prayer she says that the portal will be reopened, how can it be reopened?
No. Now she's saying she'll pay the remaining amount in installments and then you can.
And then it can be reopened.
All right. Counsel for the applicant states that the balance amount will be paid in 2 equal installments or 4?
6 within 6 months, 6 installments.
In 6 equal monthly installments. Beginning 1st May 2022. The installments will be paid positively by the 10th of every month. If the entire amount is paid, then
let's say in the meantime, my RC may be restored so that I will run my business. Since December 2020, since December 2020.
No, but what's the guarantee? Then the same question arises.
I'll file undertaking, let's say, before the officer.
Then let me take instruction, my lord.
Only let's say the clients who were going to the appeal, they are not depositing anything and their RC is revised. But here also because of the invoke of Rule 23, let's say entire amount I have to pay, including tax, interest, penalty, late fee, everything. So since
that is a choice you people make.
I'm sorry, let's say, but he is unable to pay. That is why I pray for only they may revoke that. I will file. Within 6 months, the petitioner will undertake before the officer. Let's say.
All right, he wants to take instruction. You say, Ms. Roy Chaudhary states that the petitioner is prepared to give an undertaking of clearing the entire balance amount in 6 equal monthly installments. And on the basis of the undertaking for the petitioner's RC to be restored.
My lord, for that I have to take instruction.
All right, Mr. Chimanka states he needs time for instructions. 5th May.
5th, not 5th.
6th May. 6th May. We'll list on 6th May. All right.
Okay.
Item number 7.
This is a review application, my lords. Certain facts which were not within our knowledge at the time of argument, my lords, they came to our knowledge. All similarly placed hotels have been treated in the manner which have been mentioned in the review application, my lords, at running page 10. These are my pleadings, my lords. Starts from paragraph 3.9, my lords. In essence, my lords, all similarly placed hotels which are holding on to land for more than 30 years, my lords, a time period has been fixed on since 86, my lords. The time period has been fixed for them, completed within 2 years, failing which we will terminate the lands. So, my lords, why should I be discriminated against? And these are all in very valuable areas, my lords. I am in a very, this is Trident, the Oberoi's, my lords, then
Given the charge at the
they have given the.
I'm sure these facts were known to you even earlier.
No, my lords. If they would have been known to us, this would have been our trump card, my lords. We were not aware of it, my lords, and neither was it revealed in the counter of the state. It was not within our knowledge. Otherwise, this would have been our trump card, my lords. We would have, because this is gross discrimination, my lords. And this meeting takes place.
2012 writ petition. In all those 10 years when the petition was pending, you didn't bring these facts and record.
No, my lords.
If you had written in an affidavit, they could have replied to it.
No, my lords, we were not aware of this.
No.
That is
in this industry, nobody is not aware.
No, my lords. Your lordships will kindly see this meeting takes place.
In fact, at 173.
At 173, my lords, your lordship, see these meetings have taken place. 173. These meetings have taken place on 22/1/21, my lords. We were not aware of this.
There are writ petitions of 2012 here also.
There are writ applications pending in this honorable court of 2012 also, my lords.
That's at 175.
Same facts, my lords. We were not aware of this.
Yes, Mr. Monty.
These facts need to be replied, my lord.
Notice, Mr. Monty accepts notice and seeks time to file a reply.
Status quo.
Reply within 4 weeks, rejoined for the next date. List on 8th July.
My lords, status quo in the meantime.
What is going to happen? Nothing is going to happen.
My lords,
They may put it up for auction.
they may put it up.
If they do, then I'm sure there will be an auction notice to start with. You can come here always. Well, once a notice is gone and review petition, obviously will not do anything. Yes.
My lord, date is fixed.
8th July, sorry.
Item number 8.
Deeply opposed.
Milord, regarding restoration of writ petition, Milord, this is for default due to my absence, Milord.
What's the main matter, sir? Tell us.
Milord, that IA, Milord, that I have filed, Milord, that is not pressed, Milord, because of the delay period of 5 days is exempt.
It's all right. The CMAPL is allowed. What is the main matter? You tell us about that.
Milord, the main matter is against the ombudsman order, Milord. Milord, that Milord, that relates to Milord, page, Milord, Lord, may I have a glance to Milord 25, Milord. Milord, order is
TOD benefit.
TOD benefit, Milord, and Milord, some other benefits.
Only for the period December 2007 to December 2009, sir. Why do you want to challenge on
Milord,
this?
it is a time-barred claim, Milord. By that time, Milord, TOD benefit is a claim, Milord, if the consumer avails power after the 12th.
What does it work out to say in terms of money? What is it? What is this benefit for the period December 2 years benefit? What is that?
Milord, it is long years back, Milord. The case was filed, Milord. Lord, case was filed.
No, you have to say in monetary terms. What does it work out to?
Well, I will give a breakout, Milord. It requires calculation, Milord, because that by that time, Milord, there was no such benefit process available in the meter, Milord. It is a special feature of the meter. Meter has that facility to record. When, Milord, the claim pertains to the period, there was no such meter was fixed, Milord, by that time, and the meter does not have the facility of recording the consumption, Milord, that what quantity of power he used during the off-peak hour, Milord. That after midnight to next day 6 a.m. Milord. That was not there at all, and subsequently when an advanced meter is installed, Milord, he has filed a case that I am entitled to get that benefit, Milord. Actually, if the consumer avails power during that period of peak hour, then the question is different, Milord. Milord, when the meter was installed, consumer was not availing power during that period, Milord. Milord, how can it be calculated, Milord? That is not there. The meter doesn't have that facility by that time, and moreover, he was not availing power supply after 12 midnight, Milord. It is an industry, Milord, and it is, Milord, it have never availed power, and it has never complained that I am entitled to this benefit. Milord, if he was actually availing power supply, he could have installed that type of a meter, which was subsequently installed, Milord. Your Lordship, see the GRF order. Milord, it is, Milord, Milord, may I place, Milord, after careful consideration of the submissions made by
detailed reply filed, sir.
Milord.
And you not filed any rejoinder.
Milord, he said that TOD benefit to the petitioner during December 2007 to December 2009 as per the preserved dump report. Milord, when the preserved dump report will come, Milord, only dump report will be derived for 1 month, Milord, preceding 1 month.
He says he availed of even during off-peak hours.
Milord, off-peak hours, Milord, that during whether he has availed that power during off-peak hour, but how can it be calculated, Milord? Because the meter installed during that period does not have that facility, Milord.
Subsequently, deliberately we did not install that kind of meter.
Milord, that is a wrong, Milord, observation, Milord.
No, who is going to go into all these disputed questions, sir? We can't we'll take evidence here.
Milord, where the dump data will come, Milord, it will be preserved, Milord. I will reply, my lord. You will also call it, my lord, next week, my lord.
sir.
My lord, next week I will be misunderstood, my lord, because on my absence, my lord.
No, we are allowing your restoration, but on merits in the writ petition.
No,
you are not satisfied.
I will prepare, satisfy, my lord, my lord. The consumers are not entitled to that benefit during 2007, my lord.
In fact, this
And
consumer has to be
moreover,
again served.
and moreover, I am not prepared on the writ petition, my lord. I am only filed after restoration, my lord. My chance will come to argue and satisfy my lord, my lord. You also may give me one chance, my lord, so that I may not be misunderstood, my lord, as a counsel, my lord. Any day you also may fix, my lord, next
In
week.
that case, we'll issue notice on this application. You first serve the other side this.
My lord.
Notice on the application.
My lord. Well, I will take notice, my lord. Because the council refused to accept notice, my lord. I offered him a copy.
I see.
But he refused to accept.
Notice returnable 13th May. All right.
Item number 9.
My lord, in item number 9, my lord, we have not received the copy of the CMAPL. We are appealing for the railways, ma'am.
Copy.
Copy.
Copy be served and council of the railways wants time for instructions. 13th May.
Oblige.
All right.
My lords, in that matter, 4 rakes per day. I forgot to point out to your lordships that 4 rakes per day.
But between now and Monday, there are only 2 days left.
Mal. It is listed on Monday. Oblige.
Specialist item number 27.
May I please, Your Lordship? Lordship, I am appearing on behalf of Mr. Bigyan Kumar Sharma. In this matter, Your Lordship, we are challenging the order of cognizance dated 7/3/2012 passed by the learned SDJ in Puri in regards to GR case number 1934 of 2010, Your Lordship. Lordship, in the said order cognizance, Your Lordship, the learned SDJ has taken cognizance against the wife under section 306 Penal Code, Your Lordship. Though the FIR was initially registered against the petitioner along with her father, mother, brother, as well as her uncle under section 302 and 34 of IPC, Your Lordship. But after due process of investigation, Your Lordship, the investigating authority could not find anything to put liability upon the petitioner along with her family under section 302 and 34 of IPC, and accordingly, they charge sheeted the petitioner under section 306, Your Lordship. Though the petitioner has been charge sheeted under section 306, Your Lordship, but interestingly and surprisingly, Your Lordship, the FIR, the person who is the informant in the FIR, Your Lordship, is the brother of the deceased, Your Lordship. But the petitioner, as well as her husband, who is the brother of the informant, Your Lordship, after the marriage was solemnized between both of them, Your Lordship, the brother who is the informant has never is in contact with the deceased, Your Lordship. As Your Lordship, the petitioner and the deceased, they both had a love marriage which was against the family interests of the family of the deceased, Your Lordship. Hence, they both were living in Puri, and the occurrence was in Puri on 12/12/2010, Your Lordship, and the informant was living at Cuttack. And moreover, Your Lordship, Lordship, kindly see Annex 3.
You've not made the informant a party.
No, Lordship.
Then, and this is only the stage of taking cognizance. You can always file for discharge. Don't have to.
FIR of the year 2010.
Yeah.
Order 2000.
All your contentions, you raise all your contentions before the court. You say, counsel, the petitioner is permitted to withdraw the present petition with liberty to raise all the contentions raised in the present petition at the appropriate stage before the court concerned. The interim order is vacated. The copy of the order be sent to the SDJ in Puri forthwith.
Obliged, Lordship.
Specialist item number 28. That 28 already trial completed in process.
Counsel, the petitioner states that the petition has become infructuous, disposed of as such.
Item 20.
Please, Lordship. Well, here the order of cognizance dated 3rd August 2012 is challenged. The present petitioner, one is the husband and the 2-3 are the in-laws, my lord. In this case, my lord, the informant is the father. He lodged an FIR after 3 months, 27 days.
All right, sir. You can raise all these pleas at the appropriate stage. There's only order taking cognizance.
Yes, yes, my lord.
Leaving it open to the petitioner to raise all the pleas raised in the present petition at the appropriate stage. The petition is disposed of. The interim order is vacated.
My lord, the Lordship may target it so that Lordship may target the trial so that
it will be open to the petitioner to request the trial court to expedite the trial. All right.
All right.
Item number 30. May I please, Your Lordship? My lord, the petitioner is the headmaster, and the opposite party number 2, who is a complainant in the court below, he was contesting for the Anganwadi helper, and her dispute was with one Ranjita Sahu. One Anganwadi appeal was filed before the sub-collector. Sub-collector directed the petitioner to make an inquiry, and the petitioner submitted an inquiry report. And basing upon that inquiry report, sub-collector passed the order. Being aggrieved, the OP number 2 filed a complaint case, and that complaint case was forwarded under section 156(3) to the police for investigation. After investigation, police only submitted charge sheet against Ranjita Sahu. Thereafter, the complainant filed a protest petition. In protest petition, magistrate has taken cognizance against the petitioner without sanction, challenging that impugned order is at annexure 6, my lord. Relevant page 42. Challenging that the petitioner before your lordship.
So cognizance sanction can be obtained any time, not at the stage of cognizance. So what? If
yes, sanction can. I am placing one judgment of Supreme Court, my lord.
Please,
my lord. and relevant person to 4 line and placing.
And he was 49. He was 49-year-old in 2012, my lord.
No.
Yes.
So
Here, my lord, the petitioner is a headmaster and sub-collector directed him to submit a report. Petitioner submitted the report. This was his duty. He has no grievance with no issue with the complainant, my lord. He submitted a report. Basing upon that report, sub-collector passed the order and the complainant filed the case against the sub-collector, CDPO and headmaster. The adjudicating authority, my lord.
All this you can urge at the relevant
he was
stage.
working as a headmaster then. Now he is, my lord, as per his
The
revelation.
cognizance
he
was
must be
taken
60-year-old
then.
now.
My lord, the cognizance was taken then.
It's all right, sir. That's okay. At the stage of cognizance, we don't need to have all this. You see, considering that the petitioner is retired now, he's retired now, right?
Lord, he is 60 now.
So must be retired.
On the verge of retirement, my lord.
Considering the petitioner is already at the verge of retirement and the order and the challenge is only an order taking cognizance, the court does not consider it appropriate to interfere at this stage. Leaving it open to the petitioner to raise all contentions at the appropriate stage, the petition is disposed of, the interim order is vacated. The order will be communicated to the court concerned.
My lord, may kindly direct the court below. The magistrate has also directed the complainant to obtain the sanction, my lord. The court below, after obtaining the sanction, can proceed.
That the court knows what to do, sir. We don't have to tell them. Yes.
Item 31. The petitioner and opinion number 2, my lord. They have got married. Now the bears with child. The one sister statement come the record, my lord, kindly see, my lord. She has said I am 19 years, my lord, and with my own volition I have married with the petitioner. That is at my lord, the flag B.
It's only a cognizance order, the same thing, sir.
When I am passing of FIR, my lord. On the ground of the petitioner and opinion number 2, they have got
The
married.
prayer is quashing the order of taking cognizance. That's the prayer. There's no other prayer. See, leaving it open to the petitioner to raise all contentions at the appropriate stage before the trial court. The petition is disposed of, the interim order is vacated. Copy of the order be sent to the concerned court. Yes.
Item 32.
None appears dismissed for now, sir. Interim order is vacated.
33.
Please, your lordship. This is an application for quashing my law, an order of convenience taken against the petitioner under section 3(1) XS SC and ST Prevention by Proceeding Act. The ground, my lord, the prosecution case is one the information lost by a lady alleging that she was a servant, maid servant in my house, and I was paying him in some amount, my lord. Thereafter, my lord, some amount she has to get from me, but I didn't pay. Therefore, my lord, when he asked for the money, I abused him also in the name of the caste because he's a civil caste lady.
So it's only an order taking cognizance, sir.
Yes. Yes, I'm coming, my lord. I'm coming. Cognizance, I'm questioning on the ground, my lord. Subsequently, the only allegation is I have not paid her dues. And subsequently, during the investigation, she filed my law, an affair saying that I have got my dues and nothing to say, I will not proceed against him. And also an affidavit, my lord, annexed, my lord. Matter has been settled up. And a recent Supreme Court decision, my lord, by the Honorable Chief Justice and Honorable Justice Suryakant, my lord, that if the matter has been settled, even if it is under the SCH Act, matter should be quashed, my lord, under section 482 by your lord.
Where is that affidavit?
My affidavit is
page 23.
Yes.
This is a one-page affidavit, my lord, which has to be verified. Let them.
Who's appearing for her? Anyone appearing for her?
Somebody has appeared, my lord. List indicates.
Yes, Mr. Aaron Raut.
And my lord, the charge sheet submits. The charge sheet indicates that he has also approached the police that I need not proceed in the case. But since it's a SCST Act case, my lord, police have
give them liberty to place all these records.
when the matter has been settled up, and when the Honorable Supreme Court has repeatedly
Let a
said,
statement be recorded by the court, so that's safer.
no, and your lordship may kindly see, I am citing a decision, my lordship may kindly see. And in that case, my lord, there was a conviction by the trial court, High Court confirmed, and when the court found that the matter has been settled up among the parties, the court directed that the matter should be quashed. There is no need of proceeding, my lord. Your lordship may kindly see this decision, my lord, by the recent decision by Honorable Chief Justice Justice Ramana, my lord, and Honorable Justice Suryakant.
Citation.
They did it 142, sir.
No, your lordship kindly see paragraph 10. Also under section 482, it is the stated by paragraph 10. So far as the first question is concerned, it would be addressed to outrightly refer to the recent decision of this court in the case of Ram Gopal and another versus state of Madhya Pradesh, wherein a two bench judge of this court, the very same bench by law, two of us, N.V. Ramanna, Sijal and Suryakant, was confirmed.
All right. All right. You say along with
there are 482 they have discussed.
The present petition. The petitioner has enclosed a copy of an affidavit dated 2nd February 2012, sworn to by the complainant, stating that all the disputes and differences between the parties have been settled and that she does not want to proceed further with the case. Counsel for the petitioner has placed before the court copy of a decision of the Supreme Court of India in Ram Avatar versus State of Madhya Pradesh, AR 1920-21 SC 5228, where the Supreme Court has, while reiterating its earlier judgment, in Ram Gopal versus State of Madhya Pradesh, bracket, criminal appeal number 1489 of 2012, bracket, held that high courts under section 482 of the CRPC are not precluded from quashing a case arising under the SC/ST Prevention of Atrocities Act in order to do complete justice. That due to matter, the court quashes GR case number 140 of 2012 and sets aside the order dated 7 July 2012 passed by the SDJM Panpo Shurkela. The petition is disposed of.
Item 34. Item number 36.
My lords, no instructions in this matter.
No instructions disposed of.
Item number 37.
But here I have challenged the order of cognizance for the offence under section 3 SC/ST Act, my lord. Considering the entire materials available on record, my lord, no case is made out under section 3 SC/ST Act. Only in the FIR, it is alleged that I have altered the caste of the.
Madam, you can take all these pleas at the appropriate
Your
stage.
lordship, the statement which was recorded under section 161, that also clearly shows that he has not altered the name of the caste.
All of you managed to get a stay for 10 years. Now when the matter goes back, even the complainant will not be there. That's what is going to happen.
Only one thing, madam. There is a case and counter case. So far, my case is concerned, which is tribal by court of magistrate, madam. 3 SC/ST is special court, madam.
I know this will go there. It's all right. Reserving the right of the petitioner to raise all the pleas raised in the present petition at the appropriate stage. The petition is disposed of. The interim order is vacated. Copy of the order be communicated to the court concerned.
May I pardon, my lord? Item 57, that order may kindly be pardoned.
Same order in 57. All right.
Item 38.
None appears. Dismissal non prosecution.
Item number 39.
I am from the DS. I am from here, Milord.
Ah, yes, tell us. 38.
Item 38, Milord. Both the parties have already, they were mutually, they settled the matter out of court, Milord. And now the opposite party has also entered the appearance, Milord. And the.
Where is that?
Milord.
Where is the settlement?
Milord, the opposite party was given the appearance and he has already given the.
Next item, it's mine.
38.
No, opposite party is given appearance is okay. Where is it that you have settled the matter? What is that to show that?
Flag B.
Flag B, is it?
Yes, sir.
The opposite party has filed a counter affidavit. No. Flag B is just the counter affidavit. Where does it say it's been settled, sir?
My lord, they have already given, my lord. My lord, it may come next week, my lord, I will give that comprehensive petition, my lord. Both the parties, my lord, they have settled the matter, my lord. Out of court, my lord.
Counsel, the petitioner states that both parties have settled the case, settled the disputes, and that he will produce the relevant documents on the next date. List on 6th May.
Obliged.
Item 39.
Petitioner challenge the order of cognizance, my lord, is taken under section 294, 506, 34 IPC, my lord. The fact of the case, my lord, the opposite member of the complainant has filed a case, 1cc case before the magistrate, and the magistrate sent the same for investigation under section 156(3), my lord. The fact of the background of the case, my lord, the son of the present opposite petition number 2, my lord, and married to the daughter of the opposite member 2, my lord. Both the petition, both the son and daughter, my lord, they are deaf and dumb, my lord. They have filed criminal case before the under section 494 DP Act, my lord. In that case, the petitioners and his son, my lord, they have acquitted, my lord. Subsequently, the allegation in this case, my lord, the complainant, the opposite one too, came
This
to
is
know
498A, correct?
Yes, madam.
You can raise all these pleas at the appropriate stage, sir. This is 498A.
Yes.
No, that in the 498 case, in that case, I have acquittal, man. I have acquitted.
Now it's 294.
Only 294 in the case filed in another in the Bhadrak district, my lord. The allegation there is a telephone and they have abused. That is the allegation, my lord.
All arising out of the same incident, my lord. It's a continuation of the first of.
Leaving
The-
it open
in
to
the-
the petitioners to raise all the pleas at the appropriate stage before the trial court. The petition is disposed of, the interim order is vacated. Copy of the order be communicated to the concerned court. Yes.
Item number 40.
My paper is short argument till next week only. Till next week, my client has been admitted in the hospital, my lord. I'm not complete instruction next week. I pray for next week, my lord.
This one, this matter.
Short argument.
Regarding issuance of NBW, my lord. Regarding issuance of NBW.
Oh.
They failed to appear, that's why NBW has been issued.
No, that is, I have a challenge the order of
1 minute, 1 minute.
Till next week only.
1 minute.
Means has been taken against a doctor.
After NBW issue.
NBW, I have not challenged NBW. I have challenged the order of cognizance.
After signature. Which item first of all?
Item 40, my lord, 40. I only pray for a short argument till next week. My client has been admitted in the hospital, my lord, for a heart attack, my lord.
All right, counsel for the petitioner states that the petitioner is unwell and seeks an adjournment. List on 13th May. Sorry, 5th May, 6th May, 6th May.
I'm obliged. I'm obliged.
None appears dismissed from prosecution.
Miller, item 41.
Yes, 41.
There are 4 difficulties. I am not getting my file. Can you lordship give me till Monday time?
All right, list on 6th May. All right, at the request of Mr. Das, list on 6th May. Right.
Item 42.
Item 42, I may be permitted to withdraw with liberty to raise all the grounds at the time of framing of judgment.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to raise all the petition contentions raised in the present petition at the time of charge.
Obliged.
Disposed of is withdrawn with liberty is paid for. The interim order is vacated. Right.
Item 43.
None appears dismissed from opposition.
Item number 44.
None appears dismissed from opposition.
Item number 45.
My lord, item 45, your lordship may kindly issue fresh notice to the complainant.
No, why? What is the matter?
Your lordship, for a moment, noting is there. Notice issued to the opinion to unsolved.
That's right. All 2012 matters, sir. What is the matter about? You tell us.
Matter is, my lord, both the present petitioners are, my lord, the government officers. One is, my lord, the sub-divisional police officer, and another is the inspector.
All retired, sir.
My lord, they have already been retired.
It's okay. Now we will raise all these pleas at the
My
appropriate
lord,
stage.
cognizance has been taken without sanction, my lord.
It's all right. All these pleas you can take, sir. You
Well,
say
both are government
reserving the right of the petitioners to raise all the pleas urged in the present petition at the appropriate stage. The petition is disposed of. The interim order is vacated.
Our own high court's judgment, my lord, without
You can
sanction,
cite it
my
all
lord.
before the trial court, sir. No problem.
Item 46.
46, my lord, on behalf of Shri Arvind Mahdi, no instruction.
No instructions disposed of.
Item 47.
None appears dismissed from non-prosecution.
Item number 48.
Item 48, my lords. My lords, here in this matter, I have challenged the order, rejection order passed by the JMFC Budville Wide Annexure 2, my lords. My lords, a 1cc proceeding was initiated against me, wherein I was the accused for a check bounce of amount rupees, my lords, 4,78,000. My lords, that check was issued by me because, my lords, the petitioner, the present petitioner and the complainant, my lords, we were in a partnership agreement. My lords, I was working as the dealer for that company. My lords, I had issued that check to the complainant as a security check, my lords. My lords, and they have fraudulently.
These are all matters for trial, sir.
My lords.
Leaving it open to the petitioner to raise all the pleas urged in the present petition at the appropriate stage. The petition is disposed of. The interim order is vacated. Copy of the order be sent to the concerned court. Forthwith. All right.
Greatly obliged.
Item 49.
None appears dismissed from non-prosecution.
Item number 50.
50, no instructions.
No instructions disposed of. Interim order is vacated.
Item number 51.
None appears dismissed from non-prosecution. Interim order is vacated.
Item number 52.
Same order. Dismissed from non-prosecution. Interim order vacated.
Item number 53.
None appears dismissed from non-prosecution. Interim order vacated.
Item number 54.
May I please your lordship? The challenge
Yes.
here is to the prosecution at the next one. Section 20 of the Complaints and Abolition Act. The complaint on the face of it is barred in law, being barred by the law of limitation, and besides that, the complaint, if your lordship takes page 19, accused is only the managing director of the company. Your lordship, the law has now been settled in.
Correct. Without the company being made a party, you can't just move against the managing director. Correct.
These are the two main grounds
All right.
for which the prosecution cannot survive. Has
All
to
right.
be set aside.
You see, in the present petition, there was notice was issued way back on 14th May 2013. In the present petition seeking the quashing of 2cc 105/2010 under section 24 of the Contract Labor Regulation Abolition Act 1970. Pending the court of the SDJM Bhubaneswar. Notice was issued way back on 14 May 2013, but till date, no reply has been filed. The two grounds on which the challenge has been raised is that the complaint has been filed only against the managing director of the company without making the company itself an accused. Stop. It is a settled position in law that without the company itself being pleaded as an accused, it's not open to a director or a managing director alone to be pleaded, arrayed as an accused. Can you give us that decision, Mr. Mukherjee?
I have made both, my lords, number 838 of 2008 is judgment delivered on Judgment delivered on 27th April 2012.
Then what's the cause title?
Anita Hadda versus this Godfather Travels and Tours Private Limited.
Amita Handa.
Anita Hadda. And the second case is a recent judgment, Dale D'Souza versus Government of India. This is criminal appeal number 1319 of 2021, decided on 29/10/21.
Noted down. The second issue on which the challenge has been raised is that the complaint is barred by limitation. Again, on this, there is no reply filed by the opposite parties. For the aforementioned reasons, the case 2C by CC by 105 of 2010, pending the court of the SDJM Bhubaneswar, is hereby quashed. The petition is disposed of.
Item 55.
My lord, is disposed of this.
Yes, disposed of.
May please, Lordship. Well, request to Lordship to come to page 10, the FIR. So that the FIR doesn't make out any offence at all. Page 10, my lord, 110.
Oh, no, 420, 406.
Yes, 420, 406. So also just see the FIR, but it's the FIR. We may, it's a small letter, we may permitted to bring to the following matters for current consideration and necessary action. As you are kindly aware, we are leading seafood, we are leading seafood exporter of frozen shrimp to various countries, and we are processing at the factory of so. We have been exporting processed prawns to Messrs. Seawealth Products in
non-payment of the balance amount.
Not payment of the balance amount. Absolutely no allegation, no lordship makes that 420, the intention of cheating has to be there from the beginning, and not only that, he also doesn't say that I have cheated, and also there is no question of pay. And also lordship will also find that in para 6 I have already stated that all the dues are paid and all that, and most interestingly, the company who is dealing, the company is not an accused here, though it is not a 138 case, but the company with whom they have been dealing as per the affair, company has not been made accused. Paul Burris, the present petitioner, my lord, he has been made accused. So my humble submission is that the FIR doesn't make out in office either on section 420 or on section 406. Well, if Lordship will permit me, I have made those decision which is law is very clear, but your Lordship can write 2-3 judgments followed. Small judgments followed.
Because the present petition is to
Informant has not been noticed. Last week,
informant has been noticed, no?
Well, despite valid service, he's been served.
No, informant is in bed putting.
Seeking the quashing of GR case number 236 of 2013, arising out of Nirakarpur case number 22 of 2013, pending the court of the SDJM Khurda. The complaint on the basis of which the FIR was registered simply states that is on the letterhead of Magnum Estates Limited, and states that they've been exporting processed prawns to Messrs. Seawealth Products Inc. in California and USA, and that they have not received payment. Stop. The residential address of the proprietor, Paul Morris Foston, was indicated in the said letter, and on that basis the FIR was registered. Full stop. Despite service of notice, none appears for the opposite party number 2 complainant.
This Safsir has been filed.
I see. A perusal of the Mr. Katke informs the court that a charge sheet has been filed in the matter. The perusal of the complaint reveals that it is essentially what non-payment of dues against supplies made. Stop. Clearly, therefore, no criminal offense was made out. It was a pure civil dispute. And yet, sections 420 and 406 IPC have been invoked. Full stop. Mr. Manoj Mishra, learned counsel appearing, senior counsel appearing for the petitioners. Petitioner is referred to the decisions in Uma Shankar Gopalika versus State of Bihar, 2005-10 SCC 336, and Ajay Mitra versus State of MP, AR 2003 SC 1069. To urge that not even a prima facie case is made out against the petitioner. So moreover, he points out that without making the proprietary concern of the petitioner a party, the petitioner in his individual capacity could not have been made a party. The Sea Wealth Products INC is a company.
Is a company,
not a proprietary concern.
not a property company.
He further points out that Messrs. Sea Wealth Products INC is in fact a company and not a proprietary concern, as wrongly stated in the complaint. It is settled law that without making the company a party, a representative or a director alone cannot be made a party to a criminal complaint. The decision Anita Hada is an authority for this proposition. Paragraph. Indeed, it appears from a reading of the complaint that it is a purely civil dispute that has wrongly been registered, as has been wrongly made the basis for a registration of an FIR. Consequently, the court quashes GR case number so and so arising out of so and so, pending in the file of SDJM Kurta, and all consequential proceedings.
People of Blakeman. This case is also the same. FIR is also exactly the same. Another amount. Lordship will
I see. Same order.
Item 56.
Parties are same also.
All right. People of Blakeman.
Item number 58.
None appears justice for opposition. The interim order is vacated. The order be communicated to the court below.
Item number 59.
No, please, ma'am. Subsequent FIR under section 498A, 323, 294, and 506.
So you can raise all these pleas at the appropriate stage, sir. You raise all these pleas at the appropriate stage before the court below. See, permitting the petitioner to raise.
This FIR has been stayed by this honorable court.
That's right. We'll vacate the stay now. You raise all the pleas before the appropriate court. Appropriate stage before the court. You say, leaving it to the petitioners to raise all pleas raised in the present petition at the appropriate stage before the trial court. The petition is disposed of. The interim order is vacated. Copy of the order be sent forthwith to the court concerned.
Item number 60.
Item number 60, I'm appearing on instruction, my lord, for the petitioner. But since the brief was earlier with Honorable.
It's all right. Sorry, tell us.
My lord, page 8, if your lordship looks at.
Yes.
Page 8 is the complaint which I'm seeking for quashment, my lord. Page 11, I would request my lords to look at. Page 11.
Yes.
Page 11 is a legal, will mention a legal notice which was sent by the complainant to the accused seeking an apology for an act which he has never done. Since I didn't tender a written unconditional apology, the complaint was filed. There's a dispute between the complainant and accused over a political agenda for which the allegation is that the complainant has alleged that the accused has circulated a particular FIR which was never filed, mentioning that the complainant has told something about the caste and creed and religion, my lord. Thereafter, he came to know about the circulation of the FIR from the near and dear ones, for which he sought an apology. The accused did not tender an apology, therefore the complaint. In my submission, my lord, it is a clash of ego between two parties having different political agenda. There is no chance of any criminal, my lord, case being initiated under section 500 of the IPC, my lord.
Has the opposite party been served? S. Mahanti appears for opposite party number 2. Complainants.
The total in complainant is
One. Complainant is 1. Witnesses are 6.
Yes, ma'am.
Amar Kumar Rautra. But now why don't you tender the apology and be done with it?
My lord, that is my that is one of the grounds which I have taken that
So
this thing if continue at some point of time I might have to tender an apology and it will be futile exercise to continue with the prosecution. My lord. Whether the complainant also wants to pursue the matter.
But you remain silent. In fact, he had given you a notice on 6th November.
My lord. That's what
It's
he says.
okay. Whenever you settle or you tender the apology, you approach the trial court. The court is not inclined at this stage to interfere with the order taking cognizance. Counsel, the petitioner states that the petitioner is prepared to tender a written apology to the complainant. As and when he is able to tender such apology, it will be open to him to move the trial court for appropriate orders.
My lord.
The petition is disposed of, the interim order is vacated. Right.
Item 61.
May I please, Your Lordship? My lord, the present petitioner has filed this application challenging the proceeding pending before the learned JMFC Jaleshwar. My lord, on the ground, my lord, the all the co-accused persons have been acquitted, and also no other material would be found against the present petitioner.
There are enough provisions in CRPC to seek discharge, sir. You avail those provisions.
Well, Your Lordship may kindly see, I have given a decision of our own High Court. Your Lordship may kindly see, in that case, my lord, Your Lordship, this is a case under section 366. Well, the victim girl has deposited before the court that she had gone to her uncle's house, and also the informant who is her brother, he has also deposited before the court below that he did not know this fact, therefore he lost the affair. And Your Lordship may kindly see page 16, the statement of the victim girl, my lord, page 16.
So you can move the trial court for all this, sir, leaving it open to the petitioner to seek appropriate remedies in the trial court on the basis of the averments in the present petition. The petition is disposed of, the interim order is vacated.
In this case, I am appearing for the informant, my lord.
All right.
Item 62.
My lord, already the trial has already closed, my lord. So far as the other only this.
It's all right. You can move the trial court, sir, for this. Yes.
May I please, Your Lordship?
62.
May I please, Your Lordship?
Yes.
My Lord, Your Lordship, may kindly see Annexure 4, page 19, that is order dated 16/5/2023. Cognizance has been taken by London Magistrate under section 294, 465, 506 IPC. Your Lordship, may kindly see the background of the case. The complaint case under Annexure 1 was filed by the opposite party number 2, alleging that the petitioners are the president secretary of a self-help group and she is the member. By mismanagement of the documents, they have out of that manner they have benefited by that way. Your Lordship, may kindly see the investigation was conducted because that complaint case was forwarded under section 4156(3) of CRPC to the concerned police station, and the investigation was made. And Your Lordship, may kindly see page 12. In investigation, it was found that the petitioners are neither the president secretary of that self-help group, nor the OP number 2 is the member of that self-help group. And therefore it is a false case. My lord, that is at page 12, your lordship may find at page 12, your lordship, para 3 of that.
Yes.
Thereafter, my lord, another protest petition was filed under Annex 3, and without considering that, without calling for that record, your lordship, that is police record, the Honorable Magistrate, my lord, has taken cognizance by the Annex 4. That is under challenge before us.
Have you served the opposite party number 2?
A notice was issued, my lord. He has appeared on receipt of the notice.
We'll send it back to the magistrate, sir.
My lord.
Counsel for the petitioner has challenged. The petitioner has challenged. Sorry, the petitioners have challenged an order dated 16th May 2013, passed by the Lord JMFC, Nimapada District Puri, taking cognizance of the offence under Section 294, 465, 506 IPC against the petitioners on the basis of the complaint filed by respondent number 2, opposite party number 2, that is 1 CC case number 242 of 2011. Paragraph. Despite service of notice and earlier a lawyer appearing on behalf of the opposite party number 2 complainant, today none appears. It also seems that despite notice having been issued way back on 25th November 2013, no reply has been filed. Paragraph. Counsel petitioner points out that an earlier complaint being 1 CC number 285 2009, filed by the same complainant, ended in a closure report being submitted by the police on 17 June 2011 to stop. Without taking this fact into account, the JMFC has, by the impugned order, taken cognizance. Paragraph. Since these facts are not in dispute, the impugned order dated 16 May 2013 is set aside, and the matter is relegated to the matter being ICC case number 242 2011 is relegated to the court of the JMFC, Nimapada, for considering afresh whether cognizance needs to be taken, particularly in view of the closure report dated 17 June 2011 in the earlier complaint 1 CC number 285 2009. Copy of the order be sent forthwith to the JMFC Nimapada. The matter will be listed there for directions on 16th May 2022.
I know.
Item 63.
Permitted to withdraw by law.
Memo taken on record. The petition is disposed of as not pressed.
I'm up on behalf of Bijago Padita, no instruction in that.
In which one?
In 63 item. Bijago Padita. No instruction.
Who memo is given in which one?
I am for the petitioner.
And you are for?
Opposite party.
It's okay. He's himself withdrawing it.
Okay.
Item 64.
None of you is dismissed to non-prosecution.
For hearing item number 65.
May I please, Lordship. I may beg your Lordship's indulgence. I have given a date chart, small date chart, because it's though a lengthy matter, but the point is very short and precise. I am the purchaser owner of the suit property. The date chart and the case citation and also the amended and the unamended provisions of the CPC and the judgments, entire judgments, I have given it. Let's see, may refer only the date chart I may refer.
Yes.
Let the case in a nutshell, let me just say, since 1980, I am in possession till now there is a hotel standing on the suit property. It was sold to me. It's basically a government leasehold land. Owner is the General Administration Department of the state government. They leased it out to Dr. Hari Krishna Mahtab, but incidentally the first chief minister, and he was the chairman of the Prajatantra Prachar Samiti. Dr. Mahtab applied to the state government in 1979 for transferring the property in my favor. The General Administration Department granted permission. A tripartite agreement was signed on 12/5/1980, serial number 3 of the date chart. For Millard, that is also the permission the GA department in the written statement filed before the trial court also. If your lordship put the LCR is there, I may refer to that. But subsequently, Millard, the opposite party number 1 and 2, claiming especially 1 Millard, who is no more, but 2 is the Indian National Congress Party, they made a tall claim that it was initially leased out in favor of the Congress Party. So therefore, they filed a title suit for declaration and etc. That the suit was decreed ex parte on 16/11/94. I am not going to the facts in detail, but your lordship may look at the approach of the Law and Appellate Court. Lord, admittedly, when the judgment was pronounced on 16/11, the decree was not drawn up. Lord, it happens that necessarily that on the date of judgment, the decree is to be drawn up. In many cases, it doesn't happen. But since the party was, Congress party was in power then, so I filed the appeal on 25/11. That is on the 10th day with a certified copy of the judgment. And my lord, as per the law, the last portion of the paragraph of the judgment is deemed to be the decree. So that is there. I'll come to that provision. My lord, on 28/11, when the matter was placed before the...
1 minute, Mr. Acharya. We'll just take it up at the end of the list. There are some matters below this.
My lord, you are simple.
We'll just finish, run through the list. We'll just take it at the end of the list.
Item 66.
None appears dismissed for non-prosecution.
Item number 67.
Wherever the interim order is vacated at. None appears dismissed for non-prosecution. The interim order is vacated.
Item number 68.
None appears dismissed for non-prosecution. The interim order is vacated.
Item number 69.
Item 69, Lordship, on behalf of my learned senior Mr. Devasnan Das, Lordship, I pray for a short adjournment. The brief has been misplaced, my lords. It's a case of conviction, my lords.
What is there in the petition, sir? Let's just see.
Conviction under section 395 of the Indian Penal Code, my lords.
Only taking cognizance, right?
Pardon, Lordship?
Oh, order of conviction and sentence.
My lords.
All right. At the request of counsel, the petitioner list on 13th May.
Great.
Item 65.
Yes, Mr. Rachar.
Yes, Mila. So that date chart, if your lordship is holding.
Yes. So we are at the stage when decree was not drawn up and appeal was being admitted.
No, Milord. Your lordship may come to what is, Milord, very strange. On 25/11, I presented the appeal with the certified copy of the judgment, but not with the decree, but since it was not drawn up.
Correct.
On 28/11/94, the matter was placed before the Learned ADJ Bhubaneswar. He is the appellate court. It's a first appeal, Milord.
Right.
Your lordship may kindly read this order. Milord, this is very important order. Office has not given any note as the certified copy of the decree is not filed with the memo of the appeal. Learned counsel appearing for the appellant has submitted that the certified copy could not be filed as the Learned lower court has not yet drawn up the decree, and for that he filed the operative portion of the judgment passed in West number 223 of 1982 by the Civil Judge Senior Division Bhubaneswar. According to Order 41 Rule 11 CPC, every memorandum of appeal shall accompany it by a copy of the decree appeal from and of the judgment on which it was founded. As decree has not yet been drawn up by the Learned lower court, Learned advocate for the appellant has expressed his inability to file the copy of the decree, but he has filed certified copy of the operative portion of the judgment. a petition is filed on behalf of the appellant praying for stay of the operation of the judgment passed by the Civil Judge Senior Division Bhubaneswar on 16/11 in West number so and so. When the Law and Lower Court has not yet drawn up the decree, the appellant is unable to file the copy of it, and according to Order 41 Rule 1 CPC, every memorandum of appeal shall be accompanied by a copy of the decree. The appellant cannot be blamed because the decree has not yet been drawn up by the Law and Lower Court. The appellant is given time, this is important, till 16/12/94 for filing certified copy of the decree. In the interest of justice, status quo shall be maintained. 16/12, without going into the copy period and all that, is the date of limitation. So therefore, the appellate court, being conscious of the fact that the decree was not drawn up, so therefore granted me time till 16/12 because it's a curable defect. The appeals court has said, at least in a number of judgments, I'll place those judgments. Appeal has not yet been admitted for want of certified copy of the decree. Put up this petition after admission of the appeal. Consciously, it is a right order. So decree 30/11/94, the decree was sealed and signed by the trial court. That is on the 15th day. Certified copy of the decree was made available to the petitioner advocate. The decree on 3/12, that is much before the time granted by the London court, appellate court. The decree was filed before the appellate court, and application was also filed to advance the date from 16/12/94. On 9/12/94, your lordship may kindly look at this order. Record is put up today on the strength of an advance petition filed by the advocate for the appellant, who has prayed to admit the appeal, as certified copy of the decree has already been filed before this court, and for stay of operation of the judgment till the disposal of the petition filed under so and so. Hard, it is seen that certified copy of the decree has already been filed. Admit, call for LCR, issue notice to the respondents fixing 31/1/95. As that was the date. That means, Order 41 Rule 11 stage is over. The appellate court can summarily dismiss it without notice to the other side. That is what, in that event, a decree would be drawn up. But here, what he did, the respondent appeared, the opposite party 1 and 2, who were the respondents in the court below, that it is not maintainable since the certified copy of the decree was not filed along with the memorandum of appeal. And the appellant could have waited for 15 days to file the appeal. Your lordship may, the exact question came up for consideration. My right to appeal is taken away. It's my property. A hotel is there standing on this. The property has recently been mortgaged with the IDBI and the Yes Bank for around 50 crores of rupees with permission of the state government. Those two orders I have also given by shape of a memo. But your lordship may kindly look at the provision. Both I have given amended and the unamended provision. Both, how it has occasioned in the failure of justice, miscarriage of justice, and my right to appeal has been taken away. He rejects the appeal on the ground that why the copy was not filed. Once it is a curable defect, once the court is conscious of the fact that the decree was admittedly not drawn up, grants time to file it, thereafter says, I passed a wrong order by invocation of power under 151 CPC. He recalls that order of admission, admitting the appeal, says that the memorandum is rejected. But my right of appeal goes. Neither it is appealable, that order, nor so revision is the only power, because that has finally decided the appeal. Nothing remains. So your lordship may kindly come to the decisions. Only the paragraphs relevant. I have given only the extract relevant para. In another, your lordship may look at this Jagadhis. That would be Jagdish Bhargav, 1961 Supreme Court. The whole judgment also I have given, Justice Rajendra Gadkar's judgment. Para 14 is relevant. The same issue, identical issue. Whether this Order 41 Rule 1 is mandatory in nature or not. Let us then consider the technical point raised by the, it's a very well discussed judgment. To save your lordship's time, I am only relying this. Appellant challenging the validity or the propriety of the order under appeal. The argument is that Order 41 Rule 1 is mandatory, and as soon as it is shown that an appeal has been filed with a memorandum of appeal accompanied only with a certified copy of the judgment, the appeal must be dismissed as being incompetent. The relevant provisions of Order 41 with regard to the filing of the decree being of a mandatory character. Lord, this is the submission. Answer is, it would be difficult to accede to the proposition thus advanced in a broad and general form if at the time when the appeal is preferred, a decree has already been drawn up by the trial court and the appellant has not applied for it in time. It would be a clear case where the appeal would be incompetent and a penalty of dismissal would be justified. The position would, however, be substantially different if at the time when the appeal is presented before the appellate court, a decree in fact had not been drawn up, as the present case, my lord, by the trial court. In such a case, if an application has been made by the appellant for a certified copy of the decree, then all that can be said against the appeal preferred by him is that appeal is premature since the decree has not been drawn up and it is the decree against which an appeal lies. In such a case, if the office of the High Court examines the appeal carefully and discovers the defect, the appeal may be returned to the appellant for presentation with the certified copy of the decree after it is obtained. In the case like the present, if the appeal has passed through the stage of admission, though through oversight of the office, then the only fair and rational course to adopt would be to adjourn the hearing of the appeal with a direction that the appellant should produce a certified copy of the decree as soon as it is supplied to him. Milord, in such a, everything has been answered here, Milord. That is exactly my cases. 67 Fulchan case also, the next case is that. Recently, Milord, Honorable Uttarakhand High Court, I have given that judgment. I have downloaded the website 2017. Milord, the same thing has been answered. It's a curable defect. Milord, your lordship, may I read this? Milord, it would be here, the Milord, this same preliminary objection was raised before the Honorable High Court. Honorable High Court repelled that contention and said, no, it's a curable defect. We have granted, rightly granted time to the appellant to produce. Milord, your lordship may read below. That is there, Milord. If your lordship would permit, I will read the, or the same thing is there.
No, not necessary.
Yes. Milord, Fulchan case is also the same thing. 67 Supreme Court 1470. Milord, the next case, if they have relied upon this judges and said so. Milord, they remitted back the matter. That is also for the restored the appeal to file for hearing. Milord, that is the limited question.
So, Mr. Acharya, if I agree with you, this has to go back.
This has to go back. The appeal, no, Milord, I have, otherwise I don't
After
have
20,
right. Say,
after 27 years.
Well, naturally, Milord, it's my property. I mean, your lordship may kindly look at the memo. Recently, it has been mortgaged by with the permission. I have given a memo, Milord. Your lordship.
All right. Let's hear Mr. Mishra. Who is appearing?
I am with my learned.
Oh,
I am appearing.
There is a decree and a substantive appeal. So there is a right.
Correct.
Before going through the submission made by Mother Senior Mr. Acharya, your lordship, I want to just place the order passed by your honor. That is order number 53 dated 21/11/2007. Your lordship,
21/11/2007.
Yes, sir. Order number 53.
Yes.
May I place it, ma'am?
Yes, please.
Heard by the counsel for the petitioner and Mr. P. Rai, senior counsel for the opposite party. Order dated 16/2/2030 brought to the notice of this court by the said order passed in civil division. It was observed as follows. Heard Mr. S.C. Parija, learned counsel for the petitioner, and Mr. Vivian Rai, learned counsel for the opposite party 1 and 2. An affidavit has been filed on behalf of the opposite party number 1 and 2 today in the court, from which it appears that against the ex parte decree in PS number 2 to 3 of 1982 dated 16/11/1994, the petition has filed miscase number 775 of 1994 under order 9 rule 13 CPC for satisfying the ex parte decree, and the petitioner has also filed TA number 97 of 95 after renumbering, and the same is now pending before the learned district court further. If that be the so, the petitioner is already availing the alternative statutory remedy, and there is no good ground to either entertain the civil division any longer or to convert the civil division into application under Article 226 and 227 of the Constitution. Mr. Parijal on the counsel for the petitioner stated that he has received the copy of the affidavit filed on behalf of the opposite party number 1 and 2 today. I want some time to obtain instruction in the matter. This matter on charge. You are subsequently, Mr. Lai, senior counsel, are relying upon the decision in the case of Shiv Shakti Cooperative Housing Society, Nagpur versus Swaraj Developer and others. AR 2003 Supreme Court 2435 is supported of this contention that being bereft of the order dated 16/2/2005 as quoted above, the civil revision cannot be maintained after amending the section 115 of the CPC. He also relies upon the decision of this court in Satyananda Ghoshal and others versus Devi and others and AR 1960 Supreme Court 941 and contending that any interim order passed during pendency of the proceeding binding the parties to the said proceeding and the operate as a adjudicator and the petitioner cannot raise the contention, which has been concluded by the interim order passed earlier. He therefore submitted the petitioner being bound by the order dated 16/2/2005. There is nothing left to decide in the civil division and same should be dismissed. And subsequently, my lord, and Mr. Rai, on the council appearing for the opposite party, will argue to the interim order to be vacated, and Mr. Bag take time to satisfy the court whether the revision is maintainable or not. My submission in the twofold.
What happened to the order 9 rule 13?
My lord,
What happened to the order 9 rule 13 application?
they have filed before the London court below because they are said ex parte.
No, what has happened to it, sir?
That position that only Mr. Acharya can tell.
Milord, all those petitions should be redundant. Milord, even there is
No. Was any order passed in that application?
Milord, I think all those petitions have been withdrawn or might have been dismissed because I don't know what is the. Milord, what happened? This Shiv Shakti is in my favor. Milord, revision, this Shiv Shakti which was cited, Milord, there are also decisions. I am not going to that part of the controversy. Milord, right to appeal is a statutory right. Section 96, Milord, confers that power on a person aggrieved. It is an ex parte suit. Whether that order 9...
No, whether a revision is maintainable against an order and appeal.
Sorry, Milord?
No. Whether a revision is maintainable against an order and appeal.
Maintainable, Milord. That is because where an interlocutory order which doesn't amount to finally decide the case in that event that has been taken away. Milord, Shiv Shakti is in my favor. You will say I have given 3 decisions. You will may again refer to that synopsis which I have given. Let's see if may kindly come to that. 2002 serial number 4, Milord. That the same proviso is there. Only where it has excluded the power of revision. So far the interlocutory order which do not have the effect of finally deciding the case. Lord, here nothing remains before the appellate court. He has finally rejected my appeal. Appeal is not pending. So
and then decided suit, not appeal.
Yes, suit or other proceeding. Kindly read the provision I have given. Paragraph 5. Prem Bakshi versus Dharamdev. Justice Fukan's, Honorable Justice Fukan's judgment. The proviso to subsection 1 of section 115 puts a restriction on the powers of the High Court in as much as the High Court shall not under this section vary or reverse any order made or any order deciding a issue in course of a suit or other proceeding. Not only a suit, other proceeding includes an appeal where the order made would have finally disposed of the suit or other proceedings. Here, Milord, it is finally disposed of because the appeal has not been entertained. Or the said order would occasion a failure of justice or cause irreparable injury to the party against whom it is made. Under clause A, that is clause A is there. Only that B has been omitted and that proviso is clause A is there. Before amendment, after amendment. I will show that I have given a chart. The High Court would be justified in interfering with an order of subordinate court if the said order finally disposes of the suit or other proceeding. By way of illustration, we may say that if a trial court holds by an interlocutory order that it has no jurisdiction to proceed with the case or that the suit is barred by limitation, it would amount to finally deciding the case and such order would be revisable. The order in question by which the amendment was allowed could not be said to have finally disposed of the case and therefore it would come under clause A. It will not come. So, Milord, I come under clause A. Whether it is before or after Shiv Shakti, I am coming, Milord. The next case, Shiv Shakti. which my learned friend realized, because it was an argument on behalf of a party. 32 para. Justice Arjit Prasad, a plain reading of section 115 as it stands makes it clear that the stress is on the question whether the order in favor of the party applying for revision would have given finality to suit or other proceedings. If the answer is yes, then the revision is maintainable. But on the contrary, if the answer is no, then the revision is not maintainable. Therefore, if the impugned order is interim in nature or does not finally decide the list, the revision will not be maintainable. The legislative intent is crystal clear. Those orders which are interim in nature cannot be the subject matter of revision under section 115. There is a marked distinction in the language of section 9. That is then Surya Dev Rai. That is the case where that order under order 39 rule 1 went, and the question arose whether 227 power can be invoked even though 115 power to intervene in the interlocutory orders is there. That is what this para 38, this sum up serial number 6. Such like matters frequently arise before the high courts. We sum up our conclusion in a nutshell, even at the risk of repetition, and state the same as hereunder. Amendment by Act of 46 of 1999 with effect from 1/7/2002 in section 115 of the Code of Civil Procedure cannot and does not affect in any manner the jurisdiction of this one. So, 2 is important. Interlocutory orders passed by the court subordinate to the High Court against which remedy of revision has been excluded by CPC Amendment Act of 46/99 are nevertheless open to challenge in continue to be the subject of certiorari. So I am not, he has already finally decided the appeal. Rejecting my appeal memo, nothing survives in the list. So that has finally, so where do I go? It is not appealable. Had it been a decree, suppose summary dismissal under order rule 11 of 41, then a decree has to be drawn up. That second appeal lies under section I could have availed a statutory remedy. Here I am remediless. A party cannot go without remedy. My grievance has to be ventilated, therefore is the revision. That is what before or after amendment, you will see I have given a chart. But it doesn't say about this. Sipsakti is in my favor. That is wrongly placed. And how 1960 Gujarat is applicable when the amendment is in 90. But I think wrongly misplaced. They have not understood the purpose. I have thoroughly gone through all those judgments. But a very research work like that. But all the judgments I have given. You will see kindly the interesting case is also 2 such cases I have quoted. The 94 Gujarat also there is a division bench judgment. That is serial number 3. A recent case is the Honorable Uttarakhand High Court's judgment. If your lordship can take little pen, only 1 paragraph, that was a substantial question of law in a second appeal, whether the first appellate court erred in law in dismissing the appeal on account of non-filing of certified copy of the decree. This is after this amendment. Order after decree that has been answered in para 14 Miller. I may request your lordship's bench clerk to hand over that. Para 14,
no, I have it.
Answer to substantial question of law, point number 2. The first appellate court dismissed the suit number so and so, Pradeep Kumar Saha Anand Ballappan, on the ground that the certified copy of the decree has not been filed by the defendant before the appellate court. In view of this court, the defect of non-filing of certified copy of the decree is curable. Therefore, first appellate court to afford first opportunity to defendant appellant to file the certified copy of the decree. The first appellate court erred in law in dismissing the appeal on account of non-filing of the certified copy of the decree, which was curable defect.
All right. Anything else?
Yes, my lord. I want to just place one paragraph of appellate court judgment where they have rejected the application on the ground this appeal has been filed, taken on the ground that on order 20 rule 6A,
right,
where the statute provide 15 days if the degree has not been done within 15 days to stipulated time, then one can approach the trial court and with consent of the trial court, they shall file the appeal. In this present case, the court has held, I may permitted to place the relevant paragraph as a para 8 internal page 14, your lordship may kindly see.
Yes.
As the degree was not drawn up by the learned trial court on the day appeal memo was filed, that is 15/11/2014, and 15 days time for the date of judgment have not been gone. the appeal memo could not have been accepted without copy of the decree with the copy of the operative portion of the judgment. But this court on a wrong submission made by the learned counsel, believing that learned lower court has given certificate according to subsection 2 of section 6A of the order 20 CPC, and the court also did not count the day to ascertain as to whether the 15 days lapse or not from the date of judgment, so as to attract the provision of Rule 6A under Order 20 CPC. So this is the case where the court accepted the appeal memo and granted time for filing of the copy of decree under the wrong impression that the trial court had given a certificate according to Rule 6A of CPC. Otherwise, the appeal memo should have been rejected on the same day. So there is no doubt that the court committed wrong in the accepting the memo of appeal without decree through law. Clearly provide that every memorandum of appeal shall be accompanied by the copy of the decree, and provision of Rule Order 20 Rule 6A CPC should have been applied to this case, because 15 days time given to the learned lower court for drawing up the decree was not passed for the date of judgment. And this is the case, my lord. This land has been allotted to the Indian National Congress and in 1960, and that foundation stone has been preceded. That Honorable Radhakrishnan has been founded the stone, and it is a mark as a Gandhi Smarik Bhavan. And accordingly, when that has been sold to somebody and that has been challenged before the court, and that challenging the sale date, we have filed the suit as a representative capacity on the National Congress and degree in my favor. And subsequently, when the decree and done up without to accompany of the decree, they filed the appeal. Appeal has been dismissed. Subsequently, you lordship, civil division that to another civil division, that is your lordship, which is tagged to this, they have also filed separate civil division. That also without accompanying the appeal, that has been rejected. That is also board in the lordship. Subsequently, third revision, that third appeal has been filed in the Khuda court matter. That also pending. I don't know what is the status of that appeal matter. And also they have filed Order 9 Rule 13 petition for satisfying the ex parte order. So there is they cannot say that they will be limitless, because they are ex parte. They can also produce the so far as the Order 9 Rule 13 application is concerned. Yeah. And so far revision is concerned, as I with respect to I disagree with my senior Mr. Acharya that courts that Shiv Shakti's cases where the proceeding has been concluded and finally. In that case, revision is maintained. Once the person, your lordship, I may permitted to read again para 32. In plain reading of section 115 and at its stand, make it clear that the stress in the question whether the order in favor of the party applying for revision would have given finality to the suit or other proceeding. If the answer is yes, then the revision is maintained. I want to give an illustration in that respect. If a application on the file under Order 7 Rule 11, if that will be rejected, that if that has been challenged in the revision, if that will be allowed to subsequently end the proceeding of the suit, in that case the revision is maintainable. But if that will allow, if that is challenge in the revision, that is not maintainable, because if that will be set aside, the suit will be continued. As my knowledge senior says that it is to decide the appeal. Once it will be decided the appeal will be continue, not the end. The proceeding of appeal is not the end. My respective submission in the revision is not maintainable, and the order passed by the appellate court is not to be interfered.
All right. Order is reserved, sir.
Only one thing may I point out.
Yes.
And, the last paragraph wherein the court, appellate court has dismissed your lordship, may kindly see the observation. I don't think, my lord, in this judgment, even on the face of it, it's cryptic. He says that the appellant should have waited for 15 days because that is the time given to the lower court to draw up the decree, and thereafter the appeal could have been filed.
That is the provision. That is the provision that is applicable.
That is not the law.
That's why exactly that has been repealed.
That
has been repealed in the subsequent amendment of the CPC matter. Your Lordship, that has been amended, the 15 days period, that has been amended in 2002.
All right, all right.
So, my lord, your lordship may kindly look at, there is a time, the less, my lord, in many cases, the trial court delays or appellate court delays for drawing of the decree. So the legislature has given maximum time for of 15 days to draw up the decree. Even before the drawing of the decree, the Honorable Supreme Court says, my lord, a party, because the right to appeal begins from the date of judgment, because the date of decree under Rule 7, Order 20, my lord, has to bear the date of the judgment. Date of decree is the date of judgment. So period of limitation, my lord, 1968 Orissa, I have given that Chief Justice G.K. Mishra's judgment. I have given that also, my lord. That period is computed from the date of judgment, not from the date of decree. The appellate court says that I should have waited for 15 days to present the appeal. And when the court itself has condoned the filing and has granted time for filing, my lord, where is the question of again recalling that order by invoking 151 power? So this, my lord, because I don't have any remedy now, that appeal is to be restored to file and reheard. He will get opportunity to raise all those questions before the
All right.
appellate court.
All right, all right.
Obliged, deeply obliged.